form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. We'll begin with the first case, Jane Doe versus Severud, and Mr. Fogel. Whenever you're ready, we'll hear from you.
Thank you, Judge. Good morning, and may it please the court. The essence of qualified immunity is notice to the affected public official of the contours of the right being asserted by a plaintiff. In this case, we have several reasons to understand that a reasonable doctor would have understood that he could not employ intrusive medical procedures to a competent individual against her consent. There is common law that goes back to the mid-13th century, cited by this court.
Just let me interrupt you there, because your proposition sort of assumes away the problem. You say competent, and this woman was came into the emergency room under an emergency order that said she was mentally ill, and that she had attempted suicide, and they didn't know what was about her, and they really just wanted to do a preliminary assessment to take blood and urine. So I think you ought to leave open the question of whether she was competent. Obviously, if you have somebody who's competent and you're engaging in a discussion about whether to treat somebody or not, we have all those cases that talk about that, and where somebody's even in a coma, the family's there and they're discussing it. We have those cases. But the issue here, I think, you have to start with the fact that she came into the emergency room under an emergency custody order, in which there was a magistrate judge had found probable cause that she was mentally ill. And of course, the doctor doesn't know anything further from that point. So I think it would be better if you phrase the question somehow, not as to assume the competence, because the doctor could well be flawed if somebody came in and was mentally ill and couldn't make the correct judgment, or was under a deep depression, or in this case possibly could have had toxic chemicals in her blood and would have died while in the emergency room. I mean, these are the issues I think you have to present to be fair to the case.
Well, the reason I started that way is because Dr. Severud, in his papers, acknowledges that she was competent to make medical decisions.
Well,
I don't know any way around the admission.
No, you can argue that. Obviously, you can argue that, but the emergency medical order, which was found by a magistrate judge, is what presented the circumstances in the emergency room to the doctors and the nurses.
Your Honor, it was not a determination by a magistrate. It was a decision by a police officer that he take her in for evaluation and testing. There was no judicial determination.
What was the language of the order?
There was no order. It's what's called a paperless order.
Paperless order, but
yes.
Wasn't it to assess the mental competence?
No, it was to assess the need for treatment, given the fact that she had just tried to commit suicide by running a tube from the exhaust pipe in the car into the body of the car. And that's what she was brought to the hospital for.
Counsel, do you contest the validity of the paperless order? I don't remember any discussion that was invalid, so that there was an order of some type.
I do not contest the seizure by the police officer or the transportation of my client to the hospital for evaluation. What I question is some of the procedures that were utilized at the hospital against the will of what I say, and I don't think it's a matter of argument when you have both sides acknowledging that the plaintiff was competent. Some of the other defendants don't specifically acknowledge it, but they say there's no evidence that she was incompetent. So I think we have to start with the proposition that both sides agree on, that she was competent. And therefore the question is, what intrusive medical procedures under what conditions can be applied to a competent person who's brought into the hospial? There is
Can I ask a question? So, one of the statements that the district court relied on was a statement that appeared in the pleadings from the other side that indicated that the doctors couldn't have known whether your client ingested other toxic substances that she chose not to disclose to increase the likelihood of success in her efforts to kill herself. Now, I've got questions for the other side about whether or not that's competent evidence, given that it appears solely in a pleading. But assume for the moment that was a concern that the doctors had, and you've got a patient who is clearly refusing treatment. So isn't it reasonable that for the doctors, assuming that that's true, that they had no idea what else might be in her system that could cause her harm, don't the doctors at that point have some leeway in deciding what treatment and how to administer it, given that she's refusing treatment?
I believe it's too broad a proposition. They might have pumped her stomach out, saying, we don't know whether she might have ingested something like barbiturates, which would affect her. They could have implanted something under her skin. No, it has to, what they do, and in this instance, it wasn't treatment, it was presumably testing, has to bear a relationship to the state's interests here. The state.
So what do you assume, Mr. Fogel? What would you say that the doctors could do in that circumstance?
Well, what they did, which was to stabilize her. There's no indication that she was not cooperative in everything but the intrusive procedures that were utilized to go beneath her skin and extract blood, to stick a catheter up her system in order to extract urine, and the very heavy psychoactive drugs that were given to her without any notice whatsoever. I think you see a pattern of conduct here where it's clear that informed consent has governed this area of the law, both as a matter of common law and as a matter of statutory law in all 50 states. This is a matter that's clear, as was set forth by the Second Circuit in that I have cited, where it says that the right to refuse unwanted medical treatment has been clearly established.
So, Mr. Fogel, let me ask you this. Now, this is a bit of a quandary for the medical professionals, right? Because if they had done nothing and your client had, in fact, ingested some other substances that they might not have been aware of, or they didn't know the level of toxicity with respect to the carbon monoxide that she had inhaled, and she had either become seriously ill or died, then the doctors would be looking at a lawsuit for their inaction. So, I mean, what are they supposed to do?
Follow the instructions of their patient. I cannot imagine that the estate of a patient who dies who had refused medical treatment would have a cause of action against the doctor.
Also, given the fact that she had arrived at the hospital based on an order that questioned her mental capacity to the fact, well, she had tried to kill herself, first of all, and then you've got this paperless custody order. You don't think that there would have been a lawsuit if the doctors had done nothing?
After the patient had said, I don't want any treatment, and the law in Virginia is that any contributory negligence on the part of the putative plaintiff, would defeat an action. So no, I don't see that as a possibility where the defendant the deceased had explicitly requested not to receive treatment. And we know
it's a little bit more preliminary. The doctors hadn't proposed any treatment yet. They wanted to know what's the lay of the land is. And at that point, they would have to make decisions. But it seems to me the doctors start off with a legitimate proposition to save life. And if she says, for instance, let me die, I'm in terrible pain. And the doctors said, oh, okay, you seem to be competent, go ahead and die. Is that the type of thing we ought to be promoting?
Well, I don't know whether we ought to be promoting it, but we certainly have a series of Supreme Court decisions that say that somebody does have the right to refuse life-saving medical treatment. That's a matter of personal integrity that, as I said, goes back to the mid-13th century.
This is even preliminary to that because they're not sure of her level of competence. They're not sure what's in her blood. They're not sure that she's not going to die in their arms. It's a very preliminary assessment. Taking urine is not intrusive at all if she cooperated. And she was already in custody. Her liberty had already been seized by the state under the order. She had been seized and taken against her will to the hospital. That was, she didn't consent to that. And so once she's in the custody of the state, they have some preliminary duties, and the blood is not that intrusive either in that circumstance. Now, she made everything intrusive. She kicked and and scrambled about, and they had to calm her, they had to restrain her, they had to sedate her. But that wasn't part of the treatment. That was an effort to get blood and urine. And I can't figure out what we tell doctors to do in our society if we can't let them carry out their oath and try to preserve life as presented to them, or at least stabilize. He didn't even know whether she needed stabilization.
Well, I'm sorry to keep arguing with you, Judge, but I think the issue of competency is one that's already been resolved. Nobody here claims of the parties that she was incompetent. One party, the key party, Dr. Severu, who was responsible for her care, specifically and repeatedly acknowledged that she was competent to make medical decisions.
Well,
that was
counsel, we'll inquire of opposing counsel where they stand on the competency issue. But so far, we've had discussion about some fairly broad principles that there really isn't any argument about in terms of the ability to refuse treatment in certain circumstances. But what's your best case, not using the broad principles, that's anywhere factually similar to this case, where you have the patient who's presented after a suicide attempt and under some form of a custody order? What's your best case in some circumstance that's analogous to that?
Well, I don't have a case on that level of specificity, but I have cited a series of state court cases and of federal cases in which it is very clearly stated that an individual has a constitutional right to refuse medical treatment, even if that medical treatment...
Nobody's going to argue about those broad principles, but we have to apply the principles to the facts of a particular case. And that's what I'm looking for here, because these facts are not similar, to my knowledge, to most of the cases or all the cases that you've cited.
Well, the only cases that hold otherwise are ones in which a third party may be affected by the failure to treat the plaintiff. And that would be obviously true with infectious diseases and a variety of other things. But the law is clear. You may not, and the ethics are clear. You must have informed consent from a competent individual before you perform any procedures. Justice Cardozo, who I quoted here, said, if you perform surgery on a patient who refuses it, you're guilty of assault. Now, that doctor may have had all the positive means at his disposal to try to help that person. But in imposing himself in performing that surgery, he has violated the right of that patient, as Justice Cardozo said, cited by Justice Rehnquist, who gave a long history of the right to informed consent in the Cruzon case, and then Washington and Glucksberg and so on. This court decided in charters in the 1980s that a person has a constitutional right to refuse treatment. What more do we need?
Mr. Fogel, does it matter that, Mr. Fogel, I'm sorry.
I was going to say the defendants would argue that
can you hear me,
has to
Mr.
have a
Fogel?
constitutional right in that particular hospital too.
Mr.
I'm
Fogel,
sorry,
can you
Judge.
hear me?
Yes, sir.
Sorry. But one of the distinctions here is that this is, as you point out, a competent person, but someone who is in lawful state custody as a result of this paperless custody order. And back to Judge Agee's question, do you have a case that says that in that context, these defendants should have clearly understood that administering treatment on someone who is unwilling to accept that treatment but was in custody was so clearly established that they ought to be denied qualified immunity?
Well, what I can refer to by analogy are the cases which uphold the right to extract blood or other substances from a criminal defendant who's not only been seized, is in custody, and is preparing to proceed to trial. If it is allowed to extract that blood for evidentiary purposes, it must be done in a way that meets the actual specific need that is projected by the state. Here, we don't know why it was done. It is all supposition, and it is all provided to you by lawyers, not by anybody else. As I said in starting my brief, this case cannot go forward without analyzing why they wanted to do what they did and whether it bore a reasonable relationship to the concerns that they had when my client was presented in the emergency room. I'm sorry, I'm way over, so I'll
Okay,
reserve the rest for my
you have
rebuttal.
you have some rebuttal, Mr. Fogle.
Yes, sir.
All right, let's hear from Ms. Lloyd.
Good morning. May it please the court. Just confirming you all can hear me because my internet has been a little bit shaky this morning.
Yes, we can hear you.
Yeah, we can hear
Great,
you.
thank you. May it please the court and Lloyd, on behalf of defendants Root, Bateman, and Carter, just to give the court a little bit of a roadmap of how we intend to split up this argument. I'm hoping to spend my time discussing the constitutional precedents on qualified immunity, while counsel for Dr. Syverud will talk more specifically about the Virginia statute that brought the plaintiff to the ER, about the state laws already decided in this case, and about the clearly established framework. So before we jump into that legal analysis, what I'd like to make clear at the outset is what the plaintiff is asking this court to do. The plaintiff is asking this court to find that the doctors in this case were constitutionally obligated when she was taken to the ER on an emergency order, having attempted suicide by ingesting carbon monoxide. When she said that she did not want treatment, they were constitutionally obligated to step back, leave her on the table, and let her die. If that was how it was going to go. Because
opposing counsel says that it's uncontested that at that point, Ms. Doe was fully legally competent to refuse treatment. What's your position?
So my position, let me frame it first by saying that we are here on a 12C motion. And so we have to take the complaint as it's pleaded. And she has pleaded that she is competent. And so at this, we can all use our common sense and think about whether that's actually true. But at this point, we need to operate under that framework. But I'll tell you why I think that her assertion of competency is really a red herring in this case and doesn't dictate the court's result. So in Washington versus Harper, she relies on that as an involuntary medication of an inmate case. The Supreme Court said that it doesn't matter if someone is competent about there can be overriding state interests which require involuntary medication if the balancing between the state interests and her objection to that treatment come out to favor the state interests. And so I understand why the plaintiff is really trying to make competency do the work for her, but it just doesn't in this case. And so the proposition—
Ms. Lloyd, can I ask a follow-up with respect to the facts here? Because you painted a rather dramatic picture of someone left to die on a table in a hospital. But I mean, and we don't have a lot of facts, and that's part of the problem in this case. But she obviously was, at least the complaint alleges, that she was having conversations with medical professionals. So it appears that whatever effects with respect to the carbon monoxide poisoning that she had suffered when the police officers found her, at least one could infer, taking the complaint to life most favorable to her, that at that point, it seemed like she was okay. And she was, at this point, the doctors were trying to gauge the state of her health, admittedly, and they wanted to run all these tests. But isn't the fact that she was declining treatment at least suggestive of the notion that whatever emergency had prompted the police officers to bring her to the hospital had largely dissipated by then?
I would disagree with that, Your Honor, and I do agree that we have to operate only on the facts in the complaint. And that's what I'm asking this court to do, is apply the facts in the law to the facts in the complaint. However, as I used to say to my jurors, we don't have to necessarily check our common sense at the courthouse door. And so here, when we're talking about the minimal intrusions of just getting some basic medical procedures, routine blood work, routine urinalysis, to determine where she is at. I understand that she can physically say, I don't want this, and she physically can violently resist, but I don't think we can draw from her complaint when she admits that she had just tried to kill herself by inhaling carbon monoxide. I don't think that we can say that the emergency is dissipated. Certainly the officer didn't think that the emergency had dissipated because he acting on taking her to the hospital for emergency treatment. She wasn't there
under your argument, if we're assuming that Ms. Doe is is competent at that point, is this your argument that the factors that you're reciting are the overriding governmental interests?
The overriding governmental interest in this case is the interest recognized by the Supreme Court in Cruzan and Glucksberg, which is that the state has an overriding interest in the preservation of life and in the prevention of suicide. And so I think specifically Justice Scalia's concurrence in the Cruzan case is helpful to this court. And I realize it's a concurrence, so I'll come back around and tell you how it's important there. But what he says is a state hospital receiving someone who has tried to commit suicide cannot be held liable for pumping that person's stomach against their wishes because of the overriding state interest in suicide. And now we're not in preventing suicide. We're not talking here about something that invasive, but the court embraced, I know that was a concurrence, but the court embraced that logic in discussing the Glucksberg case about assisted suicide, about that overriding state interest in preventing suicide. And
that's all good law that appears relevant to this case, but I mean, did the district court make that sort of analysis?
So the district court decided this case on the clearly established prong, which this court most absolutely can do as well. We can have this academic analysis of the right at issue here, but what it really comes down to this case is clearly established. I think something that was really important that plaintiff's counsel just said is that I admit that there's no case on the level of specificity of this case. And now that really ends the ball game for him here. If there is no specific case from the Supreme Court, from this court, that would have guided the doctor's actions here, then qualified immunity is automatic, and he's conceded that. And so part of the issue with his argument is that he is defying what...
Ms. Loy, I'm sorry. That's not exactly right, because we have said that we haven't said that in each and every case, if a plaintiff can't show a specific case on all fours, qualified immunity fails. It all depends on the context, doesn't it? And the level of specificity with respect to the right. So let me ask you a question about sort of the extent of the treatment here, because again, we're dealing with this really sparse complaint, and it appears that the doctors in this case went from 0 to 60 in a hurry. I mean, she refused treatment, and then there's some evidence about restraining her, I think, and then all of a sudden they're injecting psychotropic drugs into her. And I think that's really the gist of the plaintiff's complaint, is that what's the evidence to show that that treatment was medically necessary on these very sparse facts of someone just simply saying, I don't want treatment? I mean, what's to say that the doctors couldn't have simply restrained her and gotten what they needed to get from her without injecting her with these drugs? I mean, there's just a level of factual detail here that's missing, that's troubling to me.
I understand where Your Honor is coming from, but the question here in this case is not why that medical treatment was necessary, which I think we can use our practical brains and determine that, but just using the facts as pled in the complaint, the question is not, well, why is that necessary? The question is, would it have been clearly established to these doctors reacting to a situation where a suicidal patient who has just tried to kill herself through carbon monoxide, that they would have had no right to treat her in any way if she did not consent? And the answer to that is no.
I don't think I'm arguing with you with respect to that broad proposition. The question is, was it clearly established that they could simply go directly to the use of psychotropic drugs in the face of someone resisting treatment?
And of course, the psychotropic drugs would have been so that she didn't injure them or herself by struggling too hard.
Well, what's the evidence in the record that she was?
I don't think she contests that she struggled so hard that she required physical restraints, even with the use of these drugs. Her complaint pleads that they tried these drugs and then they physically restrained her in order to get her urinalysis done.
Let me ask you a little different question before your time runs out. If a woman in a similar circumstance is brought to the emergency room by her daughter, and the daughter says she just tried to kill herself, and we don't know what treatment she needs, and the doctors did all of this, and she protested, would the constitutional right be different? I'm trying to highlight the fact that in this case, the plaintiff was in the custody of the state, and the state has certain duties of people in its own custody. And one of them, I suppose, is to try to protect the person's life when presented with an emergency. And I take it in this case that had they done all the assessments, very preliminary assessments, and found nothing threatening, they then could have recommended mental treatment or counseling or whatever, and she could have rejected that. But I sort of believe that what's alleged in the complaint are some initial steps taken to assess somebody who's in the custody of the state and who's clearly in risk of harming that person's self. And I'm not sure the state's free to do nothing in that in a custodial circumstance like that. But I'm trying to explore the constitutional right in the whether it differs when somebody's in custody as opposed to when somebody just walks in the emergency room. I know there's a statute on the emergency room business where the doctor has to stabilize somebody before they leaves, but can you help me on that one?
Absolutely, Your Honor. And you're right that it would be different if you just had a daughter bringing her mom in. The doctors don't see anything in her that maybe corroborates that. Maybe that would be closer to this court's prior precedents, such as in the Bailey case, where there wasn't probable cause that she was a danger to herself. But here instead, and Your Honor, I can't tell if my time has gone over because my timer froze. So please stop me. Please know that I'm not going over
go ahead and
intentionally.
finish briefly.
Okay, thank you. The doctors in this case were not only not told by constitutional precedent to treat her, they were told by constitutional precedent to treat her, versus the Hill versus Nicodemus case out of this court that said that pretrial detainees, the state must prevent suicide, must immediately take steps to prevent suicide if someone presents with suicidal ideation. And so with that, I'll turn it over to Mr. Peretz. Thank you so much for listening.
Ms. Lloyd, I'm sorry, before you stop, I have one additional question. And so, which I mentioned, which I previewed with respect to Mr. Fogel. The district court in this case hung its hat on this statement that appears in the responsive pleading from the defendants that Dr. Severud couldn't have known, quote, whether Doe ingested other toxic substances that she chose not to disclose to increase the likelihood of success in her efforts to kill herself. That to me makes a lot of sense. It would seem logical that that's true, but that's not a fact. I mean, that's just an assertion in a pleading. And so it gets back to my point about the sort of the sparseness of the facts in this case and whether or not this is a case that might be better left to decide later on, because I think if a doctor had actually said that in a declaration, it would seem to be a slam dunk at that point. So what's your response to that?
I'm going to say three quick things since I know I'm over. One, qualified immunity should be determined at the earliest possible time in a case. And it's our contention there is sufficient evidence in this case to be able to conclude that the doctors would have basically been derelict in their duty if they had just left her on the table. Two, while I agree that that is a statement in a pleading and it's not part of the complaint, which is what we're operating off now, I'm going to return to my invitation to the court to use its common sense. And three, we don't need that statement to win, because when she concedes she was suicidal, she was in state custody as a detainee being brought in for emergency treatment under 808I, that she did not consent to treatment, and that the doctors did minimally invasive medical diagnostic techniques in order to determine what to do with her. And again, we don't have any additional actions the doctors did that are complained of. Just these, what this court and the Supreme Court has termed minimally invasive techniques of blood tests and urinalysis to determine where to go from here, that we can win on qualified immunity at the pleading stage. Thank you so much.
All right, thank you. Mr. Peretz, we'll hear from you.
Thank you, Your Honor, and may it please the court. Mark Peretz on behalf of Dr. Severud, and I'd like to begin where my co-counsel, Ms. Lloyd, left off in responding to the question that was just posed. I do agree it's a matter of common sense to make a statement such as the doctors did not know whether she had ingested other substances, they did not know how much carbon monoxide she had ingested, et cetera. Those are matters of common sense rather than specific facts. But in addition to that, what we have in this case is in the
actually, just and not that anything needs to boost what you just said, but it seems to me when there is no knowledge, then the possibilities, the whole range of possibilities are available for discussion. And the whole role of the doctor is to eliminate the speculation and to find out what's going on. And so that the taking blood and urine to conduct analyses is precisely to find out if those types of possibilities are there. And I don't think a doctor has to, or there has to be an allegation that the doctor didn't know whether toxic stuff, or the whole purpose for the assessment is to decide the unknown, is to shed some light on the unknown. But anyway, I didn't mean to interrupt you at this point on that.
That's all right, Your Honor. Your point is very well made. And to buttress that point, we have specific allegations in this case in the complaint that what the doctors were doing was for the purpose of evaluation, to explore those issues and to find out what was going on. And in particular, that appears in paragraphs 14 and 16 of the complaint, among other places. But another very important point that we have in this case is, hypothetically, if we checked our common sense, if we did not look at those specific allegations of the complaint, we still have the fact that the doctors in this case are entitled to exercise their professional judgment in evaluating and treating and doing other things pursuant to their professional obligations. We have cited in our brief the Youngberg case as well as the Farabee case, which discuss that standard, which discuss the deference due to the doctors in exercising their professional judgment. And
yeah, but you see the problem that takes you to the same criticism that you probably have of the plaintiff's complaint, the generalities. I mean, you take a cruise-on situation, and the doctors had the ethical duty and the professional duty to save and protect life, and their best judgment is to provide life mechanisms. And yet the law says again and again that the individual has a broad right to make those decisions. And so I'm not sure the general notion that a doctor is entitled to freedom from liability in the exercise of his professional judgment. I think you have more serious problems here, more particular problems. What you have is an emergency with unknown facts where a person's in state custody and tried to kill himself or herself. And the rest of the circumstances are unknown, but this is all presented to the doctor. What is the constitutional status of the doctor at that point? And it seems to me there is no constitutional right to suicide, but the doctor operates against that background all the time.
Yes, Your Honor, that is correct. And that goes to the issue of making sure that we define the right specifically enough and narrowly enough when we are putting ourselves in the position of the reasonable physician in this instance. But before I leave this professional judgment point, I wanted to emphasize that in Farabee and Youngberg, and this is the critical point for this case, is it is the burden on the plaintiff to allege the absence of professional judgment. And if, as the point has been made, we have no idea why they did what they did. Now, we don't necessarily agree with that, but if we take that proposition, that the record does not show why they did what they did, that is fatal to the plaintiff's case, not to the defendants, because the plaintiffs have the burden of alleging and showing the absence of the exercise of professional judgment. Again, that is crystal clear.
The counsel, I think this illustrates the concern that Judge Niemeyer's question raised, because the plaintiff says, well, I was competent. And if you, in the abstract, if you take a competent patient, then that limits what the physician can, it would seem to me, what the physician could claim in terms of the exercise of their professional judgment if you have a competent patient who refuses certain types of medical treatment. I mean, it seems like to me that's a threshold dilemma here, whether this person was competent or whether or not the fact of the suicide and the custody order takes it out of that realm.
Yes, Your Honor, and we agree that every situation is different and every situation must be evaluated on its own, whether a person is competent, whether a person is incompetent, whether a person is competent but has attempted suicide, whether a person is unwilling to submit to an evaluation to determine their medical condition, whether they have been seized under an emergency custody order, as in this case. We are not talking about a blanket competent person with no other alleged facts. We are talking about a person who has been validly seized pursuant to an emergency custody order with certain factual predicates that go along with that, including that they have mental illness, that they are a harm to themselves or others.
But I think the response of Judge Agee and me is to your argument, emphasis on the fact that the doctor exercised professional judgment. And to me, that not only is irrelevant, but it hurts your case if it's dependent on that. The idea that it's assumed the doctor's exercising judgment. The question is whether he has a right to exercise his will, and contrary to her will. And that's more the issue. It's not whether he has a right to exercise his judgment. We're not talking about the doctor's constitutional rights to practice medicine or the level of it. And so I'm not sure I understand how pursuing this course of argument helps the case or is possible at this status in the case where you have allegations of complaint which don't even talk about the professional judgment of the doctor.
Certainly, Your Honor, and the issue is raised simply to respond to the questions earlier and the point raised by the appellant that the absence of any knowledge or facts about why the doctors did what they did is somehow fatal to the case. And I was simply pointing out that under Youngberg and Faraday, it's the opposite. But Your Honor, we agree that the critical analysis here is not necessarily the exercise of the doctor's judgment. It's the fact that there is no case, and we discussed this earlier today, there is no case that is similar factually to this case. There is no case in which a person was seized pursuant to an emergency custody order when the person was suicidal, when the person was brought to an emergency room and they were unwilling to consent to measures for an evaluation. There is no way for the reasonable physician to know that conducting this evaluation, taking a urine sample, taking a blood sample, putting in restraints, all the things that are alleged in the complaint, there is no case that is even remotely close on the facts to inform the reasonable physician that their actions would violate a constitutional right. So what we have here is not only the absence of a case and the absence of anything that we can look to show we have knowledge by these reasonable physicians in this circumstance that their actions would violate a constitutional right, but we have the Virginia statute, which specifically informs this process and instructs the physicians to do exactly what they did. Now, there are a couple of reasons this statute is important, but I want to point out, even in the absence of this statute, there is qualified immunity because the plaintiff, the appellant, cannot point to a particular case or a particular circumstance that would inform these doctors that their actions would violate the constitutional right. But the existence of the statute further emphasizes to the doctors, this is what they are supposed to do. This person was brought in pursuant to an emergency custody order, was transported to the facility for evaluation and treatment. That's exactly what was occurring here. It would have gone very smoothly had she not refused a urine sample and a blood sample, but she refused. And so other things were going on as well. But all of those things were done pursuant to this statute. And until a court informs physicians in this circumstance that they should not follow this statute, qualified immunity is something that must be imposed. My time is up, so thank you, Your Honors.
Thank you, Mr. Perlis. Mr. Fogel? You'll have to unmute yourself.
You're mute.
I didn't do that. Sorry.
Thank you. Yeah, that's good.
First, I want to quote from this court's opinion in United States versus Charters in 1987. Quote, "The doctrine of informed consent provides that a patient has a right to be informed of the value and possible consequences of a treatment and to refuse to consent to that treatment." Now, with that statement, what is it that Dr. Severide should have known? He should have known from Cruzan, Glucksburg, Washington, that she had a liberty interest in not having intrusive medical procedures. And let me just, as an aside, these are not minimally intrusive procedures. I've set forth in my brief case law, which has suggested these are serious intrusive procedures, including the use of those psychotropic drugs, including the use of physical restraints in order to secure the information, and we don't know why that information was necessary. The notion that you can apply your common sense is interesting, but it's also interesting that Mr. Carter, who was the chief nurse, gives a very different reason than Dr. Severud does as to the reason why such blood tests and urine were necessary. So it's not clear that there was any rational reason between the two of them why those tests or examinations were necessary. And so I urge you to recognize that this case cannot proceed without knowing why those procedures were necessary, how necessary were they, did the doctor consider—
Why is that relevant to our analysis now? It seems to me the allegations of the complaint basically were that she's presented in an emergency context. She's in the custody of the state, and the doctors are given the background, and they start taking their steps. And your argument or claim in the complaint is that this violated our Fourth Amendment rights. And it seems to me that's as far as we have to go in this case, is whether the Fourth Amendment rights were violated or whether the doctors were immune from any such suggestion, because a reasonable doctor in that circumstance would not have understood that he couldn't do that.
Well, what the defendants are arguing is that having somebody brought into the hospital who tried to commit suicide, they could not be questioned with anything they did. That the presumption has to be that the doctor was acting in accordance with regular principles, that the doctor had no animosity, and the further assumption as to the reason why the doctor did it. The Supreme Court has already said that a state's interest in the protection of life, and that's the only interest that's been asserted here, falls short of justifying any plenary override of individual liberty claims. And that's what at issue here. An individual liberty claim—
Well, I respectfully suggest that that's too broad for what we're facing, because we're facing a situation more analogous to when the state goes into a home and seizes a woman for abuse of children and takes her into custody, or an inmate in the custody of the state tries to commit suicide, or any other person in the custody of the state tries to harm himself, and on an emergency basis is taken to the hospital. It seems to me that is the context we're in, isn't it?
Well, again, when the Supreme Court says that a person has a right to refuse—
Of course they do. They have a right not to even go to the hospital. But in this case, she was seized by the state and taken to the hospital. So now at that point, her rights, if they didn't have a right to take her to the hospital, you should be going back and arguing they had no business in seizing her. Now, why did the state have a right to seize her?
Because in the opinion of the officer, as authorized by the statute, it was his belief
And
that
that
she was
wasn't
attempting.
unconstitutional. That abuse of a constitutional right. That's a liberty interest that was violated, right?
No, because he asserted probable cause, which he had, to believe that she had attempted to commit suicide. And the statute authorizes.
Well, once you go down that slippery slope and say that she is legally in the custody of the state has a higher level of responsibility under the Constitution. And all the cases that talk about the situations where people suffer injury or aren't treated properly or their lives are not protected while in custody. I mean, they have all these prisons have these situations where they put people on suicide watch in order just to prevent that liability. And the suicide watch imposes further intrusions, and lights turn on and they come in and check the person and he's upset because his sleep's been disturbed. And we get these cases.
Yes.
And so the real question is, where do we see where a doctor is held to have violated a constitutional right when he addresses the presentation of a person in state custody who's tried to kill herself?
Well, again, the difficult question here is, contrary to the cases that you refer to, those cases describe the precise reason in the record for what was done and why it was done. We have no such indication.
No, we don't have a malpractice claim. We have a question here of whether the doctors are allowed to leave her alone or the doctors proceed with what they thought they should be doing. There's no allegation that the doctors committed malpractice. The allegation you're making in this case is that her liberty interest was infringed.
And the doctor asserts, I can do anything I want. But the answer is, we don't know why the doctor wanted that information. And there has to be a pretty good reason in the record why he wants to engage in intrusive medical procedures, psychoactive drugs, extraction of blood with the use of subcutaneous methods, the extraction of urine in a very embarrassing and painful way. We don't know why that happened. And I think it would be improper for this court to simply say, well, it's a matter of common sense that most doctors would or might do that. We need that information in the record. And that's why the question
I have is, why do we need it? In other words, the allegations of the complaint are the infringement on a liberty interest. It's not on a malpractice claim checking the doctor's judgment. In other words, had the doctor just took her blood pressure and took her pulse, that's another assessment that the doctors do. She could have refused that too. We're talking about a liberty interest and the doctors infringing the liberty interest by trying to take blood and get a urine sample.
Well,
but anyway,
again,
I understand your argument, but I think you have to, the specificity is important in this case because we do have the suicide attempt and we do have the seizure, state seizure of her against her will, brought into the emergency room, and her rejection of the whole process. She didn't want to be there. She didn't want treatment. She didn't want to have blood taken. She didn't want to give her urine. And we understand that, but I think the issue here, you sued under Section 1983 in the Fourth Amendment, and that's the issue, is whether her liberty interest was violated in those circumstances. Isn't that the issue?
Yes.
Yeah, I thought.
Let me, if I just may finish, if the court rules in the way you seem inclined to rule, what is also important here is that the doctors get information about what the extent of their authorization to conduct procedures against the wishes of a competent individual, where there's been no court adjudication. And the irony here is that if the person were incompetent under state law, the doctor would have had to go to court to get authorization to do this. That's the irony. But we had a competent person, and so they assert we don't have to go to court. Thank you very much, Your Honors, for your.
Thank you, Mr. Fogel, and thank you to all counsel for your arguments. We ordinarily, as a custom of the Fourth Circuit, come down and greet counsel, and it's something we miss. I don't know if the lawyers miss it, but we've always found it to be a nice.
My mask.
Yeah, well, anyway, we greet you from our remote positions, and thank you very much for your argument, and we'll proceed on to the next case.
Thank you, Judge.
Thank you, Your Honors.
Avakian or
Avakian, long
Avakian.
A's.
Avakian. Close?
That's good. I know who I am.
All right, you may proceed.
Thank you, Judge. May it please the court, I'm Michael Avakian, attorney for Appellant Forcier, and I'd like to reserve 5 minutes of my time for rebuttal. Since I have the entire panel from the previous case, I'm going to omit some factual background remarks because I think you have some familiarity already with the matter. But this case considers whether the undisputed facts in the record establish Forcier must pay an exit contribution to the pension fund. We believe there are 3 critical issues for resolution. One, whether settled contract law allows other documents not identified or referenced in a signed document to be incorporated, whether the wage sheet contains terms commonly found in Me Too pre-hire agreements that adopt CBAs by conduct, and whether the exit contribution is established consistent with the requirements of Section 302C5 of the LMRA. On appeal, of course, the district court's determination below is looked at for error and all inferences in favor of Appellant Forcier. On this developed record,
Counsel,
the court is no.
Let me ask you a couple of preliminary questions.
Sure.
Fraud in the execution of the agreement appears to be an exception to the general rule that you could raise as an affirmative defense. I think that you've argued that, but the district court ruled that it wasn't raised below and therefore that's waived. Is that a position that you're advancing today, that you're entitled to raise the fraud in the execution of the agreement argument?
There's 2 parts to that, Your Honor. But the answer is yes, but that's not the grounds for our appeal of the district court's decision. We believe we were surprised and by the claim that the wage sheet was a signature page, and that occurred first in a deposition of the 30B6 witness, which was well after the case was remanded from this court back to the district court.
And second question, which kind of leaps ahead probably of where you were going, but the one way to look at the wage sheet and the other agreements is, did your client sign off on them? And obviously the only thing they signed was the wage sheet. But when they were terminating their relationship with the union, 1 or 2 of the letters also said, well, we're terminating our relationship with the Contractors Association. So if we determined, for instance, that the wage sheet was a standalone document and did not incorporate the other agreements, if your client was a member from the beginning of the Contractors Association and the terms of its relationship with the Contractors Association would have embraced these other agreements, then that might be a basis for the fund to claim that you were bound by all of them. But that's a long way around the barn to say the only evidence I see of your relationship with the association in the record is in the letter saying, well, we're going to withdraw. Is there any other evidence in the record that establishes Forcier's relationship with the Contractors Association?
Your Honor, no, there is no other evidence. The depositions indicate they were not members of the association. They were providing notice to the association, not that they were a member, because they were told to do that.
Thank you. Didn't mean to interfere with your train of thought.
Let me just ask you on that. That's a little, I have the letter in front of you here, and it says, when our contract, this is to the association, when our contract expires on April 30, we will not renew. We have notified the union of our decisions to withdraw from the association at the end of our contracts. So what's he saying when he says, I want to withdraw from the association if he wasn't already a member of the association?
He was repeating the demand of, I shouldn't say demand, the outline of how the union believed that Forcier should withdraw, which is to utilize a specified duration termination provision in the contract and notify the association. So he did all those three things in consonance with the request that the business manager of Local 58 requested of him to do.
Why would he have to do that if he didn't feel bound by the agreement?
I agree with you, Your Honor. There's a maybe a slight disconnect there, because it's not necessary to go through all those hoops to notify a union of contract repudiation. But in this case, he went about and notified everybody that he could that he was going to terminate the wage sheet agreement that he utilized on April 30th.
And even his first letter that he didn't send, where before the union gave him advice, he said, we're opting not to renew our contract agreements. He wrote that letter on his own. And they wrote back and said, you can't just do that. You have to give the notice and so forth. And so he gave the 150-day notice. And in the 150-day notice, he starts referring to specific time periods of the contracts. These letters aren't that innocent, I don't think. Don't we have to hold them to those?
Well, I don't think so, Your Honor. He's articulating an intent to get out from under at least his wage sheet. I mean, that's what he was referring to.
He didn't talk about a wage sheet. He talked about the plural. He talked about our contract, and he talked about agreements in the plural. And he wrote two separate letters.
Right. There's some inconsistency in that, Your Honor, but the intent is to terminate, and that was the reason he was doing that. The record shows the Forcier principals clearly were operating solely under the wage sheet and had no notice of the other documents until the summer of 2015, when the results of the default judgment case were provided to it. But I don't think, for purposes of how clear a writing of an individual that was not did not have counsel to write a deliberate letter that would have been carefully crafted in the situation should be held against them for this particular purpose.
Not held against them, but he sort of seems, or maybe it's your brief, but he seems to want to play dumb and saying, I just agreed to charge some wages at a level so that I can get some pension benefits. That's really where he comes out. We went up to Syracuse and talked about it, and they gave me the wage sheet, and that's all it was about. But he went up there knowing that he had to join the union to get those benefits, and they did come back, and every member in the plant, what are the 8 people or something, all joined the union. This is how much more does he knows all these contracts, the CBAs are there. He gets some assistance from the union, not a lot, but he takes advantage of a few of the benefits that the union provides. And
well, I disagree, Your Honor. He was certainly an unsophisticated person that went and signed the wage sheet, because that's what he got when he went down to Syracuse, as you indicated. And that's what he did.
What's he talking about when he talks about he's terminating contracts? He clearly intended to terminate contracts, and he did it on his own before the union gave him advice.
He was only referring to the wage sheet, Your Honor. His repudiation notice applies to whatever is out there.
Contract agreements as a wage sheet? That's what you argue?
Right. That's right, Your Honor. Because he had no knowledge of the other documents when he signed the wage sheet, and that's an important factual part of the development here. But in terms of what we find with the mechanism of the district court employed to hold Forcier liable, we will look at normal contract law as the Supreme Court has outlined in cases such as M&G Polymers versus Tackett and CNH versus Reese. But to get there, we need to understand how the exit contribution was developed and what was open for exploration and discovery by the court's remand back to the district court. It was clearly premature from the court's determination. It was premature for the district court at that time on the motion to dismiss to find incorporation by reference into the wage sheet, or incorporation by reference at all, and illusory contracts was not appropriate at that pleading stage, and also to that the validity of the amendment process to add the post-expiration exit contribution was something that could be explored and developed further in the case. Nothing in the standard form, for instance, expresses any intent to bind an employer, for instance, to every term of a trust agreement or to make post-contract payments. And there's case law that we've cited in our brief to deal with that.
I understand your position at this, and we're at grant of summary judgment, correct?
Correct. Yes, Your Honor.
Right. Your client's position, as I understand it, is that this is the district court resolved factual disputes, which it can't do at this stage. And one of those factual disputes is your client say, we signed the wage sheet, that was it. We don't know anything about these other documents. Is that correct?
That's right, Your Honor.
So if that's yet to be resolved with fact finding, what may be in these other documents, if your client's position is we don't know them, is that relevant to your argument today?
Well, actually not, Your Honor.
You understand my question?
I think so. I think if I can restate what you're saying, you're asking whether our knowledge of what may be in some other agreement, such as a standard form, may create obligations on my client, and I don't think that's the case. When we look at the wage sheet, which is the only document signed here, it uses the terms, and we may disagree. It uses the term merely a wage sheet, and merely has clear definitions and legal definitions and ones that are used in general English grammar, and that means it's solely what it says it is. The district court indicated that the word merely meant it was a part of something else, which is not the normal usage and not the legal usage as we set forth in our brief. The actual terms are: this is merely a wage infringed rate sheet furnished to all employers for immediate guidance. The new contract and its addenda will be forwarded to you as soon as it is available. And we know from cases such as 32 BJ North Pension from the Second Circuit.
How do you interpret that? I interpret that just commonly. It says this is merely the wage and infringement sheet, and the whole contract will be sent to you later. That this is just a part of the big contract, which you'll get later. Isn't that what that is? This is only merely or only the wage portion of the contract, right?
No, Your Honor. And I disagree, Your Honor.
Okay.
And for two reasons. One is the language of the document itself says the new contract and its addenda will be forwarded to you as soon as it is available, meaning it's not available. Secondly, the record evidence indicates that the new contract that they were that is referred to in here is another wage sheet, not another standard form or any other or addenda. Which may be read into it, and so if that's an issue of fact, then that should not have been resolved at this stage.
Well, I thought these two sentences were making a distinction between a rate, a sheet, a wage sheet, and a new contract. In other words, they use two different terms. So it looks to me like the wage sheet was anticipated to be a portion of the whole contract, which we'll send you as soon as it's available. Well, it doesn't exclude the fact that there's an existing contract.
Well, it's certainly saying that the new contract will be forwarded when it's available, but that does not bind Forcier to a current contract that is alleged to exist, such as a standard form.
Is it your position that whatever the contract is that's referred to in that language, is it your position your clients never got that, whatever it is?
That's correct. They didn't get it until about 3 months before they sent the notice of repudiation. So it was the following year.
Can I ask a question which is related to what Judge Niemeyer was getting at earlier? And let's assume for the moment that you've made a good argument about the Me Too agreement and the factual disputes that are in the record or may exist in the record as to whether or not they actually expressly signed a contract. But Judge Niemeyer's point was that there's all manner of conduct here which suggests a ratification of the agreement, even if not expressly assented to in writing. One is the manner in which they terminated the agreement. That is that they abided by the conditions by which someone would have to get out of the CBA. But then there's the fact that for 2 years they in fact paid benefits or contributed to the pension plan over a course of 2 years. That at least one employee actually has vested and is receiving benefits under the plan, that there was an apprenticeship program that employee participated in pursuant to the plan, that the company complied with a payroll audit that was required under the terms of the agreement. And the district court cited a number of these things that it said supported the notion of ratification by conduct. And we have a case, Plumbing Services, that says that is another method by which an employer can agree to sign on to a collective bargaining agreement. So why isn't that alone sufficient to suggest affirmance in this case?
Right. Let me take it in almost reverse order. In the Plumbing Services case, that was a withdrawal liability case. That was a case not brought directly under 515, which is the operative section here under ERISA that the case is being brought against Forcier on. Rather, it was simply utilizing the multi-employer withdrawal liability piece, and that's the basis upon which the adoption by conduct was applied, not in the circumstances that we find here. And in that case,
irrelevant to the holding in that case. The holding in that case was that the conduct created the obligation without the signature. And in this case, not only do we have the list of things that Judge Diaz just asked you about, but we also have those letters. Those letters may not be contracts, but they're indicative of and furtherance of all the lists that Judge Diaz pointed out. And it may be that the indicators here are stronger than Plumbing Services, aren't they, or not?
I don't think so. There is no evidence of. That's another issue because it's a factual one, which is whether there was any effort of Forcier to comply with the contract. They certainly made erratic contributions because there was no time in the wage sheet for upon which payments were to be made to the trust fund, and that's what got them in a bunch of trouble with the trust fund to begin with, because they never knew about all the requirements that the trust fund had. As Your Honor, I have a couple other arguments. I'll have to rely upon my brief for them.
Yeah. And you have some rebuttal too.
I'm writing into my rebuttal time at this point.
Okay.
Thank you, Your Honor.
Yes, sir. Ms. Barties.
Good morning, Your Honors. May it please the court. I'm going to address a number of the concerns that you just raised with Mr. Avakian, including your questions regarding the letters in this case. But first, I want to start by addressing where we are in this case. In the first appeal, this court laid out a roadmap for basically 4 steps for the pension fund to succeed on its claim. And those factors were first that Forcier had to be bound by the collective bargaining agreement and thereby bound by the trust document. Second, that the trust document provided that a participating employer was required to pay an exit contribution under certain circumstances. Third, that the trust document was further amended and clarified to make clear that that obligation survived the termination of the contract. And finally, fourth, that Forcier failed to pay the exit contribution. Here, that fourth factor was not disputed before the district court. Forcier has not paid the exit contribution despite the circumstances arising requiring that contribution under the trust document. As to the second and third factors, this court was definitive in its holding that the trust document was incorporated into the CBA. And this court had before it the language of the collective bargaining agreement, and it quoted it, finding that the parties agreed to make contributions and to be bound by any trust document.
We quoted that because that was what was recited.
Yes, Your Honor. And that goes to
the complaint. It was still a matter of proof, and you've got the documents in now, but it looks like to me that the first issue you raised is really where the crux of the appeal is here.
It is, Your Honor. And on that count, the district court correctly determined that there were two independent bases for Forcier's liability. And that's that first, it signed a Me Too agreement, or in the alternative, as Judge Diaz was discussing, that Forcier was bound to the agreement by its conduct. Now, when we're talking about the collective bargaining agreement in this case, we're talking about an integrated three-part document. It's the standard form of union agreement, the addenda, and the wage and fringe.
Right, but in the prior opinion, again, we were just reciting what was in the complaint, because at that stage, in effect, we had no evidence. So there are places in the district court's opinion in this second case where it appears to take some of our language in the prior case as if it were given, as opposed to still subject to proof, which it would be at the summary judgment stage. So if we start with the wage sheet, which is the only document that Forcier signed, there have to be facts that show that agreement embraced all the others. And Forcier's position is, as I understand it, we signed the wage sheet and that's all there is. And that the district court made factual findings that it should not have made at the summary judgment stage.
I don't believe that the district court made factual findings that it should have made. The facts that the district court relied on were undisputed. The discussion that you all had with Mr. Avakian at the start of his argument about whether or not they were a member of the Contractors Association, that fact I think is disputed, but ultimately it's not a genuine issue that would have weighed one way or the other for summary judgment. Because what matters for the purpose of a Me Too agreement is that the employer didn't negotiate the contract for itself. And in this case, that is undisputed. Forcier did not negotiate this contract.
Right, that begs the question of, well, what's the contract? I mean, that's the fact to be proven. And Forcier says, we signed a wage sheet. That's the only thing we ever got. We never saw any of these other documents, and we never executed any document that would incorporate them in some way. I mean, that's their factual position. So if it would appear that there is a disagreement of material fact on whether or not any of these other agreements were adopted by virtue of signing the wage sheet.
I believe that the district court correctly looked at the wage sheet and the undisputed facts that are in this case and determined that it was a reasonable interpretation of the wage sheet, that it was a part of a greater whole. If this court doesn't agree,
why is that? What are those facts?
It is that the wage sheet provides that it's not a standalone document, and that
where does it say that?
It's the language that was discussed in Mr. Avakian's argument regarding merely. As Judge Niemeyer noted, the district court correctly determined that the statement that it's merely guidance, immediate guidance for the contractors, the district court made a reasonable interpretation that meant it was not a standalone document. If this court
the Forcier people say, well, whatever this new contract is, that doesn't bind us to whatever may have existed at that point. It would have been a new contract, and we never got it. Now, they may be wrong, but it seems like to me that's another material disputed fact that could not be resolved at summary judgment.
If that's how this court views this case, then, and if it disagreed with the district court's determination that the employer bound itself to the full agreement by conduct, then the appropriate remedy would be a remand on that dispute.
We look at the case based on the facts, and so I'm asking you as counsel for the trust what the facts are that leave it as undisputed to support your position. Because as long as there are material facts in dispute, regardless of how they might be resolved at trial, you can't grant summary judgment.
Well, you wouldn't be able to grant summary judgment on this argument, but as the district court held, there was a separate independent basis for finding that Forcier was bound to the collective bargaining agreement, and that was by adopting the agreement by conduct. Here, there are various ways in which the employer acted with an intent to be bound by the contract, as this court found the standard to be in plumbing services. They're not listed in the wage and fringe sheet. For example, it complied with the pension fund's request for an audit. It used the pension fund's online system. Both of those are required in the addenda to the agreement. Forcier and its employees received health insurance and followed the rules necessary in order to do that. As Judge Diaz—
Well, again, not to be the devil's advocate, but as I understand Forcier's argument, they say, well, we simply complied with the wage sheet when we did all those things, because the pension fund shows up in 2 or 3 places on the wage sheet, and the fact that they may have used an online system instead of sending in a check, that's not inconsistent. It doesn't appear to me that that's inconsistent with the wage sheet as a standalone document. It may also be consistent with the other agreements, but unless there's something substantial that they did that was inconsistent with the wage sheet, that would still follow their argument in this case.
The wage sheet is a summary of the benefits and the fringe rates and the wages that need to be paid. So, of course, we would see the employer in this case comply with the wage sheet. But the factors that I'm listing are requirements of the full collective bargaining agreement that the employer also abided by. For instance, it abided by the contract's 7 a.m. start time. It had one of its employees enrolled in the apprenticeship program and received training through that program. And I think the letters here are the best evidence. As this court noted, those letters show that this employer was abiding by the termination clause of the standard form of union agreement. And let me note the timing. The first letter it sent before it received the instruction from the union was sent in around November 20th of 2015. That was just before the 150 days was about to run. The 150 days would have run around December 1st. The timing shouldn't be lost here. Even before the union told the employer what to do, the employer knew that it had to take that action 150 days out. And then it listened to the union's instruction. It didn't say, we're not bound to the agreement, so we're not going to make those, we're not going to follow your instructions. It followed the instructions. It referenced that it was withdrawing from the employers association and terminating its contract agreement.
Forcier says, as I understand it, we just wanted to get out, and we would do whatever they told us to do so we could get out.
At the time that it had the termination, the time it was sending those termination letters, I do want to point out that it's undisputed that Forcier had the full collective bargaining agreement, including the standard form and the addenda at that time. Those documents had been served on the company through the default action that had taken place earlier in 2015. I'll also point out that it received a letter from the union in December 2014 regarding the illegal use, the contract violation of the use of personal tools. And that document referenced by name the standard form of union agreement with a citation to the article. At no time during this period did Forcier say, we're not bound to this contract, or we don't know what you're talking about, we've never seen it. Instead, it manifested an intent to be bound by the contract through its conduct. We think that the district court was correct in that determination. And when you compare this case to plumbing services, I think that becomes apparent. Judge Niemeyer, I agree that this is a case where we have factors that are even greater than the factors considered by this court in plumbing services. One other note about that case is that the withdrawal liability in that case, the withdrawal liability statute states that delinquent withdrawal liability is collected under Section 515 of ERISA. So there is no distinction between that case and this case on that ground, as Mr. Avakian suggested. Additionally, this court noted that in plumbing services, the employer was belated in its objection to being bound to the collective bargaining agreement. It didn't say we're not signatory to this until the withdrawal liability assessment came out. And that belated action is here as well. We have a case where an employer did not stand up and state, we're not signatory to this contract until the fund assessed the exit contribution here. As to Mr. Avakian's additional arguments, we don't believe that there is a Section 302 issue here. The collective bargaining agreement serves as the written basis for the contributions to be made, and that's whether or not signed by the employer. We also don't believe that there are any issues with regard to the trust documents in this case. The employer misquotes this court in both its opening brief and its reply brief, saying that this court left open for remand flaws in the pension fund's trust documents. And that's simply not what this court said. This court said that the district court should not have dismissed the pension fund's claim at that time based upon perceived flaws in the amendment process. Now, as this court stated in the first case, the amendment was ultimately irrelevant because the original trust document, the one that was in place at the time Forcier either executed the agreement by signing the wage sheet or became bound to the collective bargaining agreement through conduct, that trust document at that time, before it was amended, already required the payment of the exit contribution. Finally, I think there's two issues in this case that are attempted to be relitigated. The first is that this exit contribution is collectible under Section 515. I think this court was clear on that in the first case, and that should not be relitigated here. And finally, the pension fund takes the position that there is no difference between a contract repudiation and contract expiration, such that this court should come to any different conclusion than it did in the first case. And I think the best example for why that's an issue being relitigated is the employer's reliance on M&G Polymers versus Tackett for that argument, which this court already said was inapposite to these circumstances. For these reasons, Your Honors, unless you have additional questions, the pension fund believes that the district court correctly decided this case and found that there were two independent bases for the liability, whether it be the Forcier executed the agreement by conduct, or whether Forcier executed the agreement by signing the wage and fringe sheet, or whether it adopted it by conduct. And I do want to address one last issue, which is the fraud in the execution that you raised, Judge Agee, on Mr. Avakian's argument. I do want to note that the district court found both that it was waived, that the argument was waived, and second, looked at the merits and found that that had not been factually developed, and found on the merits in favor of the fund on that position. And I do want to note the surprise on the signature page. It doesn't matter what we're calling this agreement, a wage and fringe sheet, a signature page, whatever it may be. At the end of the day, it's where employers sign this agreement. And so we do not believe that there was any surprise that would have prevented the employer from raising those issues more fully during discovery or through its answer. And for those reasons, we believe that the district court's decision should be upheld.
All right. Thank you, Ms. Barties.
Thank you.
Mr. Avakian?
I think he's muted.
Hopefully you can hear me now.
Yes.
A lot of ground was just covered dealing with various issues. The most recent one that was dealing with the trust fund agreements. The court's decision, previous decision, allowed for the determination whether activities of the trust fund were taken in an appropriate manner. As we set forth in our briefs, none of the trust fund documents are signed. There's no indication that any trustee ever agreed to any changes in the trust fund to allow the exit contribution. And there's no signed signatures on the trust documents as they were developed through over 20 years of documents that we acquired. And the court has that information available to it. I do recognize that we have a situation dealing with those particular documents. Whoa. Somehow my camera, I don't know if, can you see me?
Yes, you're okay.
Okay. Mine went out, but that's all right. I'll continue to talk.
We can see you and we can hear you.
Then I just can't see you, so I'll just have to remember. I'm sorry. with regard to the establishment of the trust, I think that's an important point, because if they can't authenticate their documents, then it's a difficult situation in which to find that there's going to be any liability. But I think one of the more important parts is what was the agreement in terms of whether it was considered to be something that whether the collective bargaining agreement, as the court understood the allegations represented in the first case by the trust fund, really did pan out in the way the discovery unfolded. As we were just talking about the signature page, it's clear that issue was never raised to this court as to what the composition of the documents might have been. In fact, there's clear recognition that what the court had before and was considering was only the pleadings of the trust fund and not the actual documents, because they never provided the documents to the district court, and those documents were never provided to the in the record to this court. So as the court has indicated, it would have been difficult or impossible for it to rule precisely on the language and make a clear determination of the law on the specific facts as they occurred here. Now, M&G Polymers and CNH are important because in the determination at this stage of the case, where we have a developed record, the court has to apply the law to the facts. And in this particular case, the district court did not apply any law to the dealing with incorporation by reference to Forcier's wage sheet, which if it had, it would have been almost impossible to decide that it became a document attached to another document because on the four corners of the document itself. And that leads to the question of the fairness of what's taken place here, and that we should not lose fact of the situation that the trust fund is trying to obtain a document or obtain relief and benefits that were not presented to it through the collective bargaining agreement. They are overstating the power of the standard form to give them complete control over the operations of an employer. And as the First Circuit indicated and stated in a very similar case of Manchester Knitting, a situation where a health and welfare fund developed a withdrawal liability provision in its own trust, that assessment and acquisition of unlimited power to impose financial obligations on an employer were illusory and unreasonable in the circumstances. In fact, the business manager of Local 58, who signed the standard form agreement and also wrote and signed the addenda to agreement and signed the wage sheet, agreed that the trust fund could not impose additional contributions on employers, unions, or employees. It was beyond the scope of the power that was delegated. There is certainly a significant question of fact of whether the trust fund could do so, and if the court were to grant the fund's request to allow it to impose these types of exit contributions without knowledge and notice to the employer community that they were doing so, it would really wreak havoc on what's happening nationwide, and as a result also create a multi-circuit conflict, because I believe that type of decision to uphold this type of exit contribution in the circumstances would conflict with the First Circuit's decision in Manchester Knitted and the Second Circuit's decision in 32 BJ North Pension. Finally, with regard to 302 of the Labor Act.
You have to go quickly because red light's on. But
oh, is it?
Yeah, but take a minute to do the last thing there.
Okay, I just wanted to say that in the circumstances of the 302, the expectation in the statute is that the contributions that are going to be allowed to go into a trust fund by the LMRA statute, it is for the sole and exclusive benefit of the employees of such employer and their families and dependents. Once those contributions are laid into the fund or assessed into the fund that way, then the fund can use those monies collectively for purposes of other uses. If the trust fund is allowed to create situations where it can take money from employers for other reasons beyond those that are set forth in 302C5, then the opportunity for fraud and for racketeering, which were the impetus for the statute, would occur. And I would conclude by saying that the Seventh Circuit in Mazzei versus Rock Around Trucking in 2001 stated that 302C5 does not allow an employer to contribute to a trust fund or on behalf of or for the benefit of individuals that are not employees of the contributing employer. For these reasons, Your Honor, we believe the district court's decision should be reversed. And if the court deems necessary to remand for trial on the material facts, including whether the standard form and addenda are incorporated in the wage sheet. Thank you. And if you have no other questions.
Thank you, Mr. Vacan. We appreciate your arguments. Our practice would be to come down and shake hands with you. And I don't want you to forget that's our practice. It's we're proud of it. We've been doing it since the 1930s, and only because of COVID have we had to avoid it. But we thank you for your arguments, and that's what we would normally say to you when we shake your hand. So thank you very much.
Judge Niemeyer, I appreciate that. I've always found it very special that the Fourth Circuit does that. It's the only
Mr. Sadowski, we have you. Can you hear me?
I can hear you, Your Honor.
Okay, Mr. Waldman, can you hear me?
Yes, Your Honor.
Yeah, okay, very good. Okay, we'll call the case of Long versus Pekoski, and Mr. Sadowski, you may proceed.
Thank you. May it please the court, Your Honor. Justin Sadowski for petitioner Sadiq Long. Normally in a case where a petitioner brings a petition to the court, the petitioner wants to be in that court. In this case is unusual. I think that the one thing both parties agree, and can you hear me? Everything's
yes,
frozen.
We can hear you.
Thank you. Sorry. The one thing everybody agrees on, I think, is that this court shouldn't be hearing this dispute, although obviously for different reasons. And I think there might be, I'm not sure, but I'm hoping my friend on the other side would agree that at least part of what the case was that the district court brought to the Fourth Circuit is not covered under 46110. We obviously believe, and I will go through why none of it is covered by 46110. But just as way of background, this case involves claims that Mr. Long is on the, it used to be called the terrorism screening database. I think the government's changed the name of it since it's, wasn't authorized by Congress. There's no congressional name for it. But it used to be called, but it's informally known as the watch list. And within the watch list, he's annotated as no-fly. So in some sense, the no-fly list is a subset of the watch list. And Mr. Long is challenging both. He's challenging his inability to fly because of his placement on the so-called no-fly list and his broader placement on the watch list. The TSA has no authority to remove somebody from the broader watch list, even under the revised Latif provision. So we think that part of that case, and I hope my friend on the other side will agree, belongs in the Eastern District of Virginia in the first place. And then if you go through the counts, I think we can find more things I think we might get less agreement on. So the procedural due process claim I want to start with, that claim, the procedural due process, the process in this case is called DHS TRIP. It's based on 49 USC 44926A, where Congress authorized or ordered the Secretary of Homeland Security, now Mr. Mayorkas, to develop a system for people who have been placed on, been told they cannot fly, to redress their concerns and get relief. At least in terms of situations with, I think generally, but certainly in situations with the watch list, DHS has sort of delegated that to the Terrorist Screening Center, which is a component of the FBI. It's also not congressionally authorized, so I don't know if it's a formal entity, but it's within the FBI. And they were the ones who were doing all of the DHS TRIP stuff until the Latif decision made changes to the government made changes in response to Latif to people who are on the no-fly list with DHS TRIP. Several of those changes were required.
Let me ask you here, under the statute 49 USC 46110, the jurisdictional issue or the venue issue for the Court of Appeals for the District of Columbia or the Court of Appeals for residency seems to arise when there's a question about an order from the Secretary of Transportation, TSA. And if I'm understanding correctly, there was a TSA order that put your client on the no-fly list and then a subsequent order that took him off. So what's the live issue that involves the question with the Court of Appeals of the District of Columbia or another Court of Appeals if your client's no longer on the no-fly list?
All right. I do want to correct one thing just for the thing. The TSA does not have authority to place people on the no-fly list. But they can take them off. But they can take them off.
And they've taken your client off.
Well, our client has been taken off, but he hasn't been he hasn't been assured under the principles for a voluntary cessation that he will be continued to be off, because the government continues to claim that he was properly placed on the first place, and there's been no abiding change in policy. That's what the Ninth Circuit held in FICRE 1. In response to FICRE 1, the government filed another a letter, much like the letter in this one, I think almost precisely the letter in this one, and that's being appealed again in FICRE 2. A decision's forthcoming that we feel fairly confident about after oral argument, but there's one is there was no abiding change of policy, and there's nothing that keeps him from putting that person on the list again, and we don't know, especially since we don't know why they were taken off the list. Now,
TSA has provided a letter and an affidavit that would seem to meet the questions raised by the Ninth Circuit and Fairkey, and they used the same language that the court in that case said was absent. So if your client is no longer on the no-fly list, what is there left for us to do in this case?
First of all, I don't think that the letter does satisfy the requirements in FICRE. FICRE required them to provide an explanation for the facts that led them to remove them off the no-fly list. That's not provided here. FICRE also required that they concede that the placement on the no-fly list was improper. That also didn't happen here. To the contrary, the letter, I believe, claims that he was correctly placed on the no-fly list. They doubled down on that in this case. So I don't think the court doesn't need to reach the mootness issue if it doesn't properly have jurisdiction in this case at this time. In our view, the better analysis is to avoid the mootness question entirely and send it back to the Eastern District of Virginia, or if it prefers, to the DC Circuit. And then when the case is before a court properly, that court can decide whether the substantive claims are moot.
All right. Anything else?
Yes. Even if you think again, if back to the 46110, so the procedural due process claims, which again we do not believe are moot, those claims, the only as applied, and the court only sent as applied claims up here, the only as applied facts relevant to procedural due process is the reasons that were provided by the TSC, not the screening center, not the TSA, for why he was on the no-fly list. Those two reasons were that he received military training, which he did as a U.S. Air Force veteran, and that he concerns about a trip.
Help us understand what exactly it is you want us to do here.
We want you to retransfer the case back to the Eastern District of Virginia. That's all we want you to do.
Well, I thought you said you wanted to transfer to DC Circuit.
I think that's in the alternative argument, is you can transfer it to the DC Circuit.
So what are we going to transfer to the DC Circuit?
You would transfer, I think you would transfer everything that was transferred to you, the whole thing, which I do agree that Judge O'Grady was unclear, and I don't know whether he was hoping maybe the court would clarify the scope of what needed to be, of what was and was not covered under 46110. But if someone's going to decide that in the first instance and it's going to be transferred to the DC Circuit may want to be the one to take the first crack at that.
So you want us to transfer to the DC Circuit all the claims that you filed in the Eastern District of Virginia that have not been adjudicated?
No, just the claims that were transferred, which from the order was the count one as applied, count one was substantive due process, count two was procedural due process as applied, count three was the standard APA claim that sort of associates the constitutional claims, and then count four.
Well, I mean, if you want us to transfer that to the DC Circuit, why'd you file it in the Eastern District?
We wanted the cases to be argued, to be heard in the Eastern District of Virginia, because that's where the defendants resided. So a different jurisdictional statute. And we have some familiarity with the Eastern District of Virginia. And so we thought that, and that the judges there, knowing the watch list a little better, would provide a better forum. And that's the plaintiff's prerogative. But if the case is being decided in the first instance, it's a thing we don't think it is. I think the DC Circuit might have is our choice for strategic reasons I don't think I even can go into.
Do I understand correctly that the district court has severed the claims in this case?
They have severed the claims. They have kept all the facial claims.
Severed some claims and sent them to us for lack of jurisdiction.
Yes.
Right? And has retained others.
Yes.
So if we carried out your wish, we would transfer whatever we have to the District of Columbia Circuit. And there'd be nothing more before us, but the district court would still have the claims that have not been transferred to us.
That is correct.
And you think that is required by 49, section 46.110?
To be honest, don't think 49 USC 46.110 applies at all to this case. I don't think. What was the role of TSA with respect to your claims? Are you challenging anything the TSA did? I think we're challenging, just like we have claims against DHS, TSA using the watch list and the no-fly list to harm our plaintiff in a variety of ways, including through the no-fly list, but those aren't orders of the administrator. The placement of the watch list was done by the screening center, and those claims lie against them. As far as the DHS trip process, I'm not even sure the DHS trip process constitutes the appeal constitutes an order of the administrator of the transportation security administration with respect to security duties and powers designated to be carried out by the administrator of the Transportation Security Administration, because I don't know who designated that. Congress didn't designate that. Congress designated the Homeland Security.
I'm trying to find out, what did TSA do in this case that you're upset about or complaining about?
They told airlines not to allow them to board because somebody else put them on the no-fly list.
They issued an order to the airlines?
They informed the airlines, for the airlines not to permit these individuals to fly to, from, or over U.S. airspace.
And the airlines have complied with that order, right?
Yes.
And so that's what you're challenging. Now, isn't that clearly under 46.110?
No.
Why not?
Because those are just we're not, because we're challenging that as sort of a secondary effect, and it's not, as far as we're aware, an order. The order to do that was not an order of the TSA administrator. That was somebody at a computer terminal doing it. It's a secondary effect.
Well, it's still under the authority of the TSA, right?
I will say I haven't thought about it this closely. I do not think the TSA is the primary defendant in this case, and I think if the TSA was severed for some reason, our case could almost entirely go forward.
Well, other than a final order from the TSA, I'm at a loss to understand what it is you want us to do. I'm at a loss to understand why these came to us and what it is you want us to do about it.
I mean, what we want you to do is to send it back to the Eastern District of Virginia so we can continue challenging the watch list and the no-fly list.
All right.
All right, anything else?
If you have no other questions, then I'll reserve the rest of my time for rebuttal.
All right. Mr. Waldman?
Thank you, Your Honor. May it please the court. My name is Joshua Waldman from the United States Department of Justice, representing the respondent, Transportation Security Administration. The plaintiff was removed from the no-fly list 16 months ago. and he was provided with a declaration.
Who removed him? Who removed him?
He was removed by the Terrorist Screening Center, which, unlike, I think there's an important distinction here to be made. The Terrorist Screening Center, and we don't dispute this, and neither does the other side, makes the initial decision of putting someone on the no-fly list. But when you file the TRIP redress request and pursue that claim for relief, TSA makes the final ultimate decision on whether to maintain or remove someone from the no-fly list.
So what was TSA's role in this particular case? What did they do in this case?
In this particular case, the plaintiff filed a DHS TRIP redress request with TSA, pursued that to the end, and at the end of it, TSA made a final agency decision maintaining the plaintiff on the no-fly list until, of course, recently when he was removed from the no-fly list. But when this claim...
Who removed him from the no-fly list?
Well, he was removed. The TSA sent a letter informing him that he was removed, and TSC sent a declaration that he was removed from the list and would not be put back on the list based on the currently available information.
So your position is that the placement, TSA's placement of him or retention of him on the no-fly list is what is operative here.
If we had a live claim, for example, if he was still on the no-fly list, which he isn't, and he brought that claim, that would be the order. The TSA order would be the one that he is challenging. Now, of course...
And if that were so, if that's still open issue, that would have to be, have to go to the DC Circuit, right?
Well, we think it would go to the courts of appeals, but we think whether or not it should be in this court or the DC Circuit is a question of venue that is separate from the question of subject matter jurisdiction.
Well, that's true. The statute blurs the two. I mean, the statute says Court of Appeals is exclusive jurisdiction, and then it only authorizes two, DC Circuit and the Resident Circuit. And the Resident Circuit is the 10th Circuit, right?
Yes, that's my understanding. That's where the plaintiff lives and
so
works. So
clearly, we are not the right place for this, for anything involving the TSA. Is that right?
Well, I think that you would not be. I understand the plaintiff's argument that this would not be the appropriate venue, but the venue, what he's asking for is a transfer of venue. And
it's also jurisdictional because the statute, if you're reading the statute fairly, they say courts of appeals are exclusive, and the only court of appeals that are qualified, which was a venue issue, is DC Circuit or the 10th Circuit.
Well, I don't, with respect, Your Honor, I don't read that venue provision as being jurisdictional. It's written in the typical way that
it's a blur. They call it venue. But then they get down to section C, and C says courts of appeals have exclusive jurisdiction to decide these issues.
Right. I think the way to resolve that, and I understand the statute is not written in a particularly clear way, separate jurisdiction and venue, the way that you might normally do. But
I mean, we don't have jurisdiction, do we?
I think you have subject matter jurisdiction, but you don't have Article 3 jurisdiction because I think the claims are moot.
Well, that's a different issue. I'll have to have some questions on that. But
yes,
but we have two jurisdictional claims. We have a mootness issue, and we have Section 46.110.
Yes,
and I'm addressing 46.110 right now.
Okay, if I may, I think it's important to distinguish between the question of whether this court would have subject matter jurisdiction under 46.110 and whether or not it would be the proper venue under 46.110. And what I would ask Your Honor to do is take a look at the jurisdictional stat 46.110. Before it was recodified in 1994, it existed as what was called Section 1486. That was originally enacted in 1958 and continued under 1994. This is discussed in this court's decision in Blitz, that was the prior statute. That prior statute very clearly sets out that jurisdiction exists in all of the courts of appeals and then has a separate section about venue. And as this court noted in Blitz, when it was recodified, Congress didn't intend any material changes. And although it kind of awkwardly, I would say, smushed those provisions together, this statute has existed since 1958, where the venue provision was different from the jurisdictional provision. So all the courts of appeals have subject matter jurisdiction, but then Congress had a venue provision. And it's our argument that if you thought that this court had subject matter jurisdiction, but not venue, you would ask the question, should I transfer? And is it in the interest of justice to transfer? And partly for the reasons you said earlier.
Congress has picked the circuits on that regard. In other words, we can't exercise discretion and overcome the venue when the venue is specific to a particular interest. Congress thought the DC circuit is available for anybody, and that's probably because the agencies are in Washington, and picked the circuit where the petitioner resides. But for us to overcome those, I don't think we're looking at a traditional transfer, a forum known convenience type of analysis.
Right, Your Honor, but with respect, I think that venue, if you agree that it's a venue provision, and I think Congress has made that pretty clear, venue has always been a waivable issue. And so even if the plaintiff, for example, if a defendant has an objection to venue but does not waive it, does not raise that timely, the issue is waived, and the court may hear it whether or not.
How did the district court get the issue, which prompted it to send it up to us?
Well,
who initiated the notion that it should be transferred to us?
Well, the district court did it. What happened is the government filed a motion to dismiss, and the plaintiff responded, and the district court agreed with the government that at least some of the claims belonged under 46-110 in the Court of Appeals. And
why doesn't that preserve the issue completely, regardless of how we do 46? In other words, the district court had that issue before it, it decided 46-110. And now
well, I agree that issue is preserved, but the question about the choice of venue between the Fourth Circuit and the 10th Circuit or the DC Circuit was not an issue that was preserved by the plaintiff below. And in fact, if you read the transcript of the hearing on the motion to dismiss at page 30, the question of transfer is brought up by the plaintiff. But they said their only argument was if you transfer to the Fourth Circuit, and they specifically said the Fourth Circuit, not all of the claims should be transferred there. That's an opportunity to say, hey, if you're going to transfer, you should go to the DC Circuit or the 10th Circuit. But they didn't raise that issue, and so I think it was waived for that reason. But we certainly don't think it's in the interest of justice.
I think this is not a clear venue jurisdiction situation. I think the statute, if we were really pressed, could be construed in various ways. And it sort of overlaps venue and jurisdiction. It selects particular courts for venue, but it then says the Court of Appeals, and it's obviously referring back to Section A, the two in play, is exclusive.
Right.
Now,
Your Honor, I would strongly urge you to look at the predecessor statute, Section 1486, which did not combine those together in the way that you're talking about, and very clearly parsed out that, and if I could quote it, that the orders, quote, shall be subject to review by the courts of appeals of the United States or the United States Courts of Appeal from the District of Columbia in a section called order subject to review. And then in a separate subsection called venue, said a petition shall be filed in either the DC Circuit or where the plaintiff lives or resides. So the Congress there very clearly separated venue from the courts of appeals subject matter jurisdiction.
What is your choice? What is your position? I'm not quite sure. Wouldn't it be easier for you to handle this in the DC Circuit?
Well, I mean, for me personally, it makes no difference to me.
I'm talking about the agency. I mean,
I would say this, Your Honor, for everything that all the reasons you said earlier, the idea of transferring it to another circuit just bifurcates the claims between
They're already
two different.
Bifurcated. They've been severed by the district court.
Well, except that if the ones that remain in the district court, to the extent it has jurisdiction, any appeal would come up to this court. But if you sent some of the claims to the DC Circuit or the 10th Circuit, there's a real potential for inconsistent judgments on overlapping claims.
I don't see how that would be. I mean, if they've been severed and the issues that have been retained by the district court are going to be reviewed, they're going to be reviewed under different statutes and different orders. Well, it'll be the TCA, I mean, the TSC, whatever it is.
Well, except, Your Honor, the district court purported, and we think this was a mistake, but it purported to take some claims against the no-fly list that were as applied and send them here, and keep the facial challenges to the no-fly list in the district court. So you would have an as-applied challenge, say, in the DC Circuit, and a facial challenge coming up eventually to this court, and we think that that makes very little sense.
What do you want us to do? What is your request?
What do you want us to do and why?
Well, first and foremost, I think you should dismiss this case as moot, because
what are you going to do with his damage claim?
He doesn't have a damage claim, Your Honor. He only seeks declaratory and injunctive relief, and that.
What's a complaint's reference to damages then?
You know, I'm a little bit at a loss to know that, Your Honor. He doesn't state a Bivens claim in the causes of action. There's no damages claim here whatsoever. He wants if you look at the relief, he asked for declaratory and injunctive relief. And so I don't know that there's any damages claim here whatsoever. So we think it's
Mr. Waltman,
46-110 would give us jurisdiction with regard to an order of the TSA on the no-fly list. There are other things, and I'm a little fuzzy on what the district court has actually sent up here, but there are more claims than just being on the no-fly list. Now your client is off. So if we reached a mootness issue, it would seem to me that that would only apply to being on the no-fly list, but that there are still other claims that are transferred to this court that would not resolve. And I would not think that we'd have any authority to send those to the DC Circuit.
Your Honor, I don't think that the district court, I agree with you that its opinion is a little bit fuzzy, but my understanding of it, and this is in our brief, is that the only claims that were sent here related to no-fly list and not to any other watch list. And those still remain in the district court.
Even if there are claims about how he got on the no-fly list or who puts him on the no-fly list, the only thing 46-110 covers is an order from the TSA. And Mr. Long is no longer on the no-fly list.
That's right.
So why does that wipe out all the other claims that are here?
We're not arguing well, I don't think those other claims are here. As I said, I think the only claims that are here are the no-fly list claims. We don't contend that his challenges to other watch lists are moot as a result of his removal from the no-fly list. But we think that those remain before the district court, which is why the district court said, whatever remains before me, I'm waiting until the Fourth Circuit rules on the transfer order. And so we're not claiming that they're moot, but we're also saying that we don't think they're before this court. The only thing the district court purported to transfer related to challenges to the no-fly list status.
Well, why don't we just transfer everything back to the district court and note that it's up to the district court to determine what's covered by 4610, and of those claims, then decide whether it goes to the DC Circuit or the 10th Circuit, and leave everything else in the Eastern District to be adjudicated there.
Well, for a couple of reasons, Your Honor. First, I think the claims, as we keep saying, are moot. So I don't see any reason why you wouldn't just dismiss them as moot as opposed to transferring them back. Normally, you don't transfer claims to a court unless that court has jurisdiction. And since it would not have Article 3 jurisdiction.
What's moot other than the fact that this gentleman is no longer on the no-fly list?
Well, those are the claims that were transferred here that we think are moot. He has 4 claims that were transferred.
Speaking in a plural term, either he's on the list or he's not on the list. He's off the list. So what other claims are there?
Well, he filed, I think, 8 causes of action. 4 of them were transferred here. They are counts 1, 2, 3, and 5 of his complaint, which correspond to substantive due process, procedural due process, APA claims, and equal protection. But all of those claims attack in different ways the no-fly list. And that is why the district court transferred them to this court under 46-110. Because all of those claims challenge the no-fly list status, which is now moot. All of those claims, as they relate to the no-fly list, should be dismissed as moot. And those are the only claims that are before this court and the only claims that the district court purported to transfer here. This is no different than the Mockdad decision in the Sixth Circuit, where the plaintiff said, but I have other claims. I'm removed from the no-fly list. They provided the same kind of declaration in that case as is provided here. The Sixth Circuit agreed that it was moot. The plaintiff said, but I have other claims. And the district court, the Court of Appeals in the Sixth Circuit said, the fact that you may have other claims doesn't address whether the no-fly list claims aren't moot. And they are moot because of the removal from the no-fly list and the declaration that was provided under penalty of perjury. So we think that that's claims that are before you, and you should just dismiss them as moot, consistent with the Mockdad decision.
If we agree with you that the claim, that the decision to remove the plaintiff from the no-fly list moots that claim, whatever that claim is, why wouldn't we simply just say that? And to the extent that the plaintiff is alleging that there are other claims not covered by that decision, that we would leave it to the district court to sort all of that out, but we wouldn't necessarily dismiss the case in its entirety. We'd simply say we're sending it back to the district court, and we'll let the district court sort that out.
Judge Diaz, that's exactly what I'm asking this court to do.
No, you're asking us to dismiss the appeal in its entirety without a direction from this court to transfer whatever claims may remain that are not covered by that are not within the scope of the jurisdictional the jurisdictional grant, and of course understanding that we may not even be the proper court. But I would suggest to you that we would simply tell the district court, it's now up to you to figure out what this complaint alleges after we're done here.
Well, perhaps I've not been clear, but that is what I'm asking this court to do. I'm not asking you to issue any judgment here on anything other than the claims that the district court purported to transfer here, which was not the entire complaint.
But Mr. Waldman, but your colleague on the other side says that those claims are broader than simply whether or not his client remains on the no-fly list. And so that's in dispute. Why shouldn't the district court sort that out?
Well, I agree. He's got claims that he says are to different watch lists, and I don't read the district court as having transferred those claims here. The district court said there's challenges to the TSDB watch list, and that he did not transfer here because he did not think jurisdiction lay under 46-110.
But I think Judge Diaz's question is coming to this issue, is that individual counts in the complaint don't seem to be limited in the scope of what they're claiming. And so when the court transfers something to us, in order to grant the relief of finding these claims moot, we might be throwing out claims that are not related to the no-fly list.
Oh, sure, Your Honor. I have no problem at all with this court saying we dismiss the claims 1, 2, 3, and 5 for mootness only respect to their challenge to the no-fly list status. And we leave it to the district court to determine whether there's any live claim and to adjudicate on the merits any challenge to something other than the no-fly list. We have no problem with that kind of order. We don't dispute that that's the proper course. And if I accidentally suggested to the contrary, I did not mean to do so. We only think challenges to the extent that they attack the TSA order about the no-fly list are moot. Not other watch list claims. I just want to be clear about that. We're not asking the court to dismiss those other claims as moot.
And so could I ask you about the mootness issue? Because early in the argument, there was a question, I think Judge Niemeyer may have asked it, about whether or not the declaration that was filed is sufficient, assuming we agree with the Ninth Circuit that there are some things the government needs to do before a claim is moot. What's your argument. I mean, it's true, isn't it, that there's no concession that the plaintiff in this case was improperly placed on the no-fly list to begin with, and it may be because the government doesn't think that that's a concession they should grant.
Right. No, the declaration does not speak to that question. But the question under the voluntary cessation doctrine is whether the challenge conduct is likely to recur. It's our view that there could be no more direct and binding answer to that question than a declaration signed under penalty of perjury that the plaintiff will not no-fly list in the future based on the currently available information. Now, questions like if the government were to repudiate an old status, which we're not doing here, or give some kind of explanation as to its change, that would at best be indirect measurement of whether whether in the future the conduct would likely to recur. And we don't see why the court would insist on that indirect evidence when there is direct evidence with a declaration under penalty of perjury that directly answers the voluntary cessation question of whether the challenge conduct is likely to recur. And in fact, what's repudiated one day can be unrepudiated another day if somebody else wants to change their mind. So it's really not binding, but you have a declaration under penalty of perjury here. That's about the strongest evidence you can have, and it's one where the information goes directly to the question that's relevant for the voluntary cessation doctrine. And that's why we think the Sixth Circuit in Mokdad, seeing the same kind of dismissed as moot, whereas FICRA, the Ninth Circuit, not seeing that declaration, did not dismiss as moot.
All right, thank you. Mr. Sadowski?
You're muted. He's muted.
Yeah.
All right. I have another point to respond to my friend on the other side. I want to start out with the TSC was the one who put him on the no-fly list. The TSC is the one, as he said, removed him on the no-fly list. The TSA's only role is through.
I thought the TSA. He said that the TSA. What really brought it here is you went through an administrative process to remove from the list, and the TSA made the decision to retain him on the list.
That deserves some that's not exactly correct, and that does deserve some explanation, though. I understand where you're coming from. We brought this lawsuit before he initiated before he initiated DHS trip in 2015. We brought the lawsuit. We, at the time, and I think correctly, argued and believed that under Darby, there is no need to exhaust. We could challenge the placement of the watch list without challenging the DHS trip process because there's nothing in the statutory language that makes the DHS trip process the exclusive means for challenging no-fly list placement. We continue to believe that. The court disagreed and denied our preliminary injunction, but because the court said incorrectly, in our view, that there was an exhaustion requirement. So maybe we should have asked for a final judgment at that point, but we thought that just going through the process would at least resolve this one-off issue and get us back going sooner. That turned out to be incorrect. It took 2 years for I think over nearly 3 years for the DHS trip process to resolve itself out. But we challenged the placement of no-fly list before we went that process, and we never, in our view, and I think correctly, had to do that in the first place. And we could have brought this case without having done that. And I don't think doing that voluntarily voluntarily after Judge O'Grady said it was necessary rather than appealing. I don't understand any legal theory that would take away our other avenues of challenging the no-fly list.
Well, after going around and around with opposing counsel, I think we finally reached a bottom line, at least from that the opposing counsel agreed to, which would be your client's no longer on the no-fly list to the extent that whatever was transferred here challenges him being on the no-fly list. That's moot. Whatever else is left goes back to the district court, and the district court can figure out everything that's left over. What's wrong with that?
This case is not moot. Another point I want to get is my friend on the other side said that it is not likely to reoccur, and that declaration shows it's not likely to recur, but we don't know that, and we can't know that, and that's the government's burden because
let's get beyond that issue. We know that issue. That's the likelihood of recurrence, and that's the exception, of course, to mootness doctrine. Well, let's assume we are satisfied that that would be moot under a couple of these cases that have addressed this issue. What's your answer to Judge Agee's question? If we were to conclude that the placement on the no-fly list is moot, wouldn't you would then be left with everything else that you're claiming, right?
We would be left with everything else that we were claiming. We wouldn't be satisfied. We don't think that we want our no-fly list claims to proceed. And we also would note that that might create a conflict with the Ninth Circuit's decision in FICRE, which I think is grounds for FICRE 2, which I think is grounds for maybe holding yourself and not making a decision prematurely. And secondly, because that would be based on lack of jurisdiction, that wouldn't be binding on any other court. So if we decided, or if Sadiq Long decided to go to the DC Circuit, the DC Circuit wouldn't be bound by your decision of mootness. And so it wouldn't necessarily resolve anything.
All right, thank you very much. We'll come down to greet counsel in a sense that we're going to greet you right here from our positions. Our normal practice is to come in the well of the court and shake your hands. And that's a tradition of the Fourth Circuit, as you probably both know. And thank you for your argument. So we're doing that now as best as we can. And we'll proceed on to the last case.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
I'll be back in
Lokova versus Halper, and Mr. Biss, we'll hear from you first.
Thank you, Your Honor. May it please the court, my name is Steve Biss. I represent Svetlana Lokova in this appeal. We are asking the court to reverse the district court's finding of sanctions and the dismissal of the claims of defamation and tortious interference with contract. It's been fully briefed, so I'm going to try not to go over all the issues in the case. I want to hit on 3 points, 3 reasons why we believe this case should be reversed. Number one, the letters at issue are not protected by an absolute privilege. The allegations in the complaint that Ms. Lokova filed are that these particular letters were delivered with one purpose only, and that purpose was to cause the termination of her book contract. And I'm going to presume that the court has familiarity with the facts in the case. Now, the case is about this concept of absolute privilege, and the Virginia Supreme Court has addressed it. There's really 2 seminal cases from the Virginia Supreme Court, and when I say seminal cases, I mean in the last 20 odd years. The Lindemann case is the case that we cited to the district court. We've also cited it extensively in our brief. And in Lindemann, the Virginia Supreme Court said that the absolute privilege does not apply to mere litigation or the mere threat of litigation. And we've cited the case extensively. The Mansfield case was decided after Lindemann, and the Mansfield case involved pre-filing demand letters, such as we have in this case. So we have pre-filing demand letters. We can eliminate the possibility that this case involves pleadings or any other type of paper that was filed in an actual proceeding, because here Mr. Helper never commenced any proceeding ever, not at all. So Mansfield adopted the restatement position that in order for the absolute privilege to apply to these pre-filing demand letters, the proponent of the letters must have contemplated in good faith. Litigation must be contemplated in good faith and under serious consideration. In our brief on page 27, we address the numerous reasons why we don't believe Mansfield applies. We address those to the district court, why we believe in good faith Mansfield doesn't apply. The issue really on from the sanction standpoint is, did we file a lawsuit in direct contravention of the Virginia Supreme
Counsel? Wouldn't it be more direct to say the Supreme Court of Virginia, having adopted the restatement in Mansfield, that the question would be whether the district court applied the essential questions from the restatement that the Virginia Supreme Court set out specifically in Mansfield, whether it had a record and a basis to determine that the requirements of the restatement were met.
Judge Agee, I actually agree that's really where no matter how you look at this issue, you get back to the issue of, is there a record? And the answer to that is no. When you look at the Mansfield, the points that the Supreme Court raised in Mansfield, you come to the conclusion that at the very least, there are issues of fact that ought to be not decided by the district court, but decided by the fact finder in this case. The Virginia Supreme Court decided a case, and this was going to be my second point, but I'll sort of dovetail into it. The Virginia Supreme Court decided a case on October 14 of 2021 after briefing. We submitted the case as supplemental authority. I think it's document 28. The case is Javago Growth versus iTech AG. And the case was, it's document 28 in the record in this case. And in that case, the Virginia Supreme Court clearly affirmed that the concept of absolute privilege is an affirmative defense. So when you look at the Mansfield principles, and I'll get more into Zhivago in a second, but when you look at the Mansfield, the points in Mansfield, clearly this case is distinguishable from Mansfield. And again, on page 27 and 28 of our brief, we cite, and I can read them to Your Honor, but Your Honor can read them just as well as I can. This particular case, these demand letters.
But it would require a factual record upon which a district court could make findings.
No question.
In this case, other than the complaint and the motion for sanctions, what record is there?
There is no other record. There's no record. So the question is, if the court accepts as true, if the district court accepts as true the allegations in the complaint, we're left with the proposition that these particular letters were not sent because of litigation that was contemplated in good faith and under serious consideration, but rather they were sent because the defendant was trying to terminate a book contract. Now, we cited in our reply brief a number of cases from Massachusetts, and the Larson case being the leading case, and the Larson case cites all the other controlling cases. These Massachusetts cases are important because they stand for the proposition that pre-filing demand letters cannot be used to effectuate unlawful acts such as tortious interference with contract. And I would commend those cases, even though they're not controlling on the court. They clearly are controlling under the facts of this case, because Ms. Lokova alleges that the purpose of these letters was solely to terminate her book contract, and that's exactly what they did. She also points. Yes, sir.
I understand that argument with respect to the defamation claim. There's a absolute privilege in defamation claims for those letters, but the letters have to meet the criteria set forth in the various cases and in the restatement. But are those letters privileged with respect to tortious interference?
Judge,
is there any potential claim that they could be protected with respect to the tortious interference claim?
No, sir. That gets me to the second point, the Zhivago growth case. The Virginia Supreme Court in the Zhivago growth case decided the implication. This is how the Virginia Supreme Court phrased it. The implication from Donahoe. Donahoe, was a case in which a lis pendens was filed, and there were claims of slander of title, which is basically defamation, and abuse of process. And in the Zhivago growth case, the Virginia Supreme Court decided, number one, absolute privilege is an affirmative defense. Number two, the Virginia Supreme Court said clearly and unequivocally that the court had never extended the concept of absolute privilege to non-defamation torts. And the court held
Well, the protection, the privilege, as I understand it, extends only to the defamatory conduct that would be contained in the letters, if you based them on the letters.
That's correct, Your Honor.
It seems to me that the issue of whether you stated a good claim, a legitimate claim for tortious interference, which is probably the thrust of your whole complaint, the letters are sort of irrelevant.
I agree with that. The Zhivago growth case says very clearly that absolute privilege does not apply to claims of tortious interference and other claims, other non-defamation tort claims. It's directly on point. I mean, it is on the question of the legal application of absolute privilege. The third point that I wanted to make was that there are, at the very least, there are factual issues for the jury to decide. The significant factual issue, the most significant factual issue, is the motive in sending these letters to only the publisher and distributor. And we look at a couple of cases that we've cited, the Fields versus Sprint Corporation case. Judge Locke overruled a motion to dismiss under Rule 12b-6 because the question was what was the intent of the defendant in taking the action that was putatively privileged. And Judge Locke in the Fields case said that the defendant in that case, the plaintiff in that case had alleged clearly that defendant did not take the action in furtherance of contemplated in good faith, in furtherance of the serious contemplation of litigation. The Rodarte case that we also cite to the court from the Western District of Virginia, Judge Conrad in that case also held that it's an issue of fact as to whether or not the defendant intended, and Rodarte involved a complaint to the police, which included defamatory material. And the Judge Conrad held in that case that it was a factual issue as to whether the defendant contemplated a proceeding in bad faith, not good faith, but the proceeding has to be contemplated in good faith. And Judge Conrad said, well, if you are defaming the plaintiff to the police, you're publishing defamatory material, or as in our case, if you are taking action that is designed, calculated to tortiously interfere with a contract, that's not something is contemplated in good faith and under serious consideration, because it's not good faith. Intending to tortiously interfere with somebody's book contract, that's not good faith. And so there are factual issues at the very, very least here.
Mr. Biss, can I ask a question?
Yes, sir.
So that statement that the letters were sent with the intent to tortiously interfere with a contract, is that a factual allegation or a legal conclusion that the district court was free to ignore?
Judge, I think it's a factual allegation. It goes to the intent of the writer and the defendant and his attorney. It goes to their intent. We have also alleged in paragraph 19 of the complaint facts that support that allegation. So number one, they only sent the letter to the two entities that were involved in the book contract. They didn't send the letter to Amazon.com, where the book was being advertised for sale, or Barnes & Noble, where the book was being advertised for sale. Clearly, it was their intent to interfere with this book contract and get the publisher to terminate the book contract, which they succeeded in doing. So to answer your question directly, I would submit to Your Honor that these are factual issues for the ultimately for the jury to decide. And there's an unpublished decision that we cite I believe in our reply brief. It might be in our main brief. It's the Coolvent case. And in the Coolvent case, this court's unpublished decision, but this court found that on the question of whether an attorney's letter was absolutely privileged, that the plaintiff that discovery was necessary. And I would submit to Your Honors that discovery is necessary in this case as well. A
follow-up to Judge Niemeyer's question about how far the privilege extends to, and you made the argument that it wouldn't. I think you're making the argument that even if the privilege would apply to a action for defamation, it doesn't necessarily extend to the separate claim for tortious interference with contract. Was that an argument that was made to the district court?
Judge, we didn't make the argument to the district court, and I would follow up by saying this: we couldn't have made that argument to the district court because the Virginia Supreme Court just decided the case some months, 6 months or so after the Rule 11 hearing took place. So we didn't have the benefit of Zhivago growth. We didn't have the benefit of the Virginia Supreme Court's clarification of the reach of Donahoe. There is nothing in any case that would have put us on notice that this is an argument that we should have raised, but clearly in Zhivago growth, clearly, and I would submit to Your Honor without any hesitation, the Virginia Supreme Court said that absolute privilege does not apply to tortious interference. Again, we filed a copy of the case as document 28, and the site is 863 Southeast 2nd,
all right.
684.
Mr. Biss, let me in the time you have left, I wanted to get in an additional question. This is a different tack, but under Rule 11 C5, the rule states that the court must not impose a monetary sanction against a represented party, who would be Mrs. Lakova, for violating Rule 11B2, which is that the claims are not warranted by existing law or their frivolous argument. And in the limited language the district court gave to imposing a monetary sanction on Ms. Lakova, it does not appear to me that the court ever addressed the specific provisions of Rule 11. But by the same token, I don't think you've raised that issue. So my question is, do you have a position on that, and can we consider it as to her individually?
Judge, I think our opening brief, I tried to lay out the extent to which the district court can sanction a party, sanction an attorney under these various rules. I would submit to Your Honor that the district court erred, and the sanction in this case was excessive. The district court dismissed her claim. The district court entered a monetary sanction against her, but I would submit that the district court erred in entering both forms of sanction. Number one, I don't think there should be any. I don't think the Rule 11 relief should have been granted at all. I mean, that's number one. But even if it was proper to enter relief under Rule 11 with no evidence, and with the facts being in dispute, I would submit to Your Honor that these are legal issues that this court could decide de novo on this appeal.
All right, thank you, Mr. Biss.
Thank you, Your Honor.
All right, Mr. Reed. You're muted.
He's muted.
Yeah. There you go.
Thank you. May it please the court. My name is Terry Reed. I am here on behalf of the appellee, Stephan Halper. And we are seeking affirmance of the trial court's discretionary decision to impose litigation sanctions. The central question here is, did the district court abuse its discretion in imposing bad faith litigation sanctions after warning the plaintiff and her counsel of this risk when dismissing the plaintiff's earlier lawsuit against Mr. Halper?
Well, I see language in the earlier decision, which the district court quoted again in the current decision, as well as the language from the Fourth Circuit that gave a warning to Mr. Biss. But I don't see anywhere in the record that Mrs. Lakova got a warning about anything.
Well, I believe the judge found that she did warn the plaintiff, Ms. Lakova. And also, I do believe that the earlier... So
where is that? I don't recall seeing that anywhere.
I believe that it is in her, the opinion at issue here, where she said that she warned Ms. Lakova. But the district courts...
Maybe you can find that and give that to the court later, because...
Okay, I'll be happy to...
I see specific language that put Mr. Biss on notice, But I haven't seen anywhere in any of the decisions or what limited record we have here that Ms. Lakova was on notice of anything.
Okay, well, I'd be happy to supplement the record with citations to that effect.
Do we have the transcript of the hearing in the record?
I don't think it is.
Is that something that's been available that we could see?
Yes, we have certainly no objections to it, but it was not provided to the court by the.
How do we know what as I understand it, the district court's reasoning that the sanction was violated because it concluded that this action was frivolous based on 2 privileged letters?
Actually, that's not completely. Right? No, the court made 2 separate, distinct, independent factual findings. One is that the suit was brought for an improper purpose, and that's to harass Professor Halper, and that's under subsection B1. She made a second finding.
So what's the record we have? What's the record we have to back that up?
Well, the district court's findings with respect to why the suit was filed for an improper purpose.
Right, I understand that, but to have findings, you have to have a record, and that's what I'm looking for, is a record.
Okay, I will recount for the court the record that the district court recited to support her factual findings of improper purpose. One, she said that under this court's consular precedent, that the plaintiff's counsel holds himself out as being experienced, just like Mr. Kunstler was. That's not clearly wrong. Mr. Biss has an extensive history of sanctionable conduct. She cited seven cases within the last 2 years that in which Mr. Biss was either sanctioned or admonished by a court. And that did not even include this case, either in the prior admonition or in the court's finding here. Those are not clearly.
All that may be true. How does any of that apply to Ms. Lakova personally?
Well, according to the judge, it applies to her because she hired Mr. Biss to bring this second suit after being warned in the first suit not to harass Mr. Halper. It was her intent to harass. But that's not these aren't the only factual findings. The court found that the both plaintiff and her counsel violated.
I don't mean to belabor this exclusively, but basically your only record here is a complaint and your motion for sanctions. And I'm having difficulty determining how the district court could make these findings you've recited if that's your record.
Well, the findings are based on the court's experience in 2 different lawsuits, Lakova 1 and Lakova 2. It's supplemented by the judicial opinions, including the opinions of this court with respect to the sanctions the first time around.
Well, that covers some predisposition and justifies the warning. But the question is, if there are new facts that occur, new harm that is created, that's a warning earlier didn't preclude a good faith suit to redress a new harm, did it?
Well, the allegation here is that the new allegation is simply repeating the prior allegations that were found to be without merit, both for
I know, but that's the question in this case.
For this failure to state a claim.
Just a minute.
By this court as well as the district court.
I understand that, but this complaint is based on an entirely new set of facts, totally different from the earlier. It's based on the book publishing contract.
The book, which simply repeats the defamatory allegations, which were the defamatory allegations in the first case.
Well, I know, but you're not hearing me out. She has a book contract which she didn't have before, and she alleges that Halper interfered with that contract, which was a pretty substantial contract, and caused it to be ruined. Now, if those are good faith allegations and are demonstrated, I don't see how that violates a notion that you can't file a harassment action or a frivolous action. I thought she based her claim that this complaint was not in good faith on the fact that he relied on two privileged letters, and he should have known that two privileged letters couldn't support it.
The privileged letters and the issue of the scope of the privilege is relevant primarily to the question of was the lawsuit as filed frivolous. The district court made a preliminary finding to that, separate under the rules, and
where's that finding?
Support.
Where's that in the record here? Let me just.
It's in, I think it's page 9 of her opinion, but it goes through these facts, what I'm trying to get through. That this has an extensive history. The violation of the court's prior warnings to plaintiff and her counsel. Can
you help me before you get there? I'd like to follow you. Where in the record? I have the joint appendix here.
I don't think it's in the opinion.
Where's the opinion? It's you didn't put that in there, I guess.
No, for some reason it did not make its way into the.
All right, I have the opinion. All right, let me get to it.
And if I could just finish off the factors that the findings that the court made that are not clearly erroneous. She pointed out that she had warned the Rakova and her counsel before, and at least to her findings, those warnings were not obeyed. That this court, it relied on the representations of this court to the district court in the first case, saying that it was up to the district court whether to join the chorus of courts that had sanctioned Mr. Biss. That's not clearly erroneous. She recounted the fact that the plaintiff and her counsel were given notice pursuant to Rule 11.
I understand all that, but I want to find out why this violated and what her reason was. And if I understand correctly, and I'm now reading from the opinion, the court found that Halper's counsel's letters were protected by the absolute privilege, litigation privilege, making the filing of the pending lawsuit by Lokova and Biss frivolous and without merit. Now, if she's wrong about that, and it's not frivolous and without merit, then her sanctions are inappropriate, right?
No.
So now give me why.
Because there are two separate findings. They're factual findings that need to be reversed as being clearly erroneous to be reversed. Okay. One is that the complaint was filed for the bad faith purpose of harassing Mr. Halper. Right? And this can only be seen against the backdrop of the prior 2 years of litigation. Second,
you can only reach that conclusion if this litigation was frivolous. If this litigation, what if she gets into an automobile accident since the last time? She can't sue for it? I mean, come on.
No, but
we're talking about
it would have to be an automobile accident by the same person over the same matter.
Well, it is. We have a book deal that was not involved before, and the book deal, she was going to publish a book, and she alleges that the book deal was destroyed by these letters, and she makes specific allegations on that. Now, the district court says that's frivolous. Therefore, it's harassing. If it's not frivolous, she can't draw that conclusion.
No, she doesn't have to make a frivolous finding to find this was for improper purpose.
She made it.
Yes, she did make it. And I'll be happy to get that. Her frivolousness finding was based on the three factors in Mansfield. One, was the statement made preliminary to proposed proceeding? She answered yes. And that was, quite frankly, the only issue. That was the only issue.
Wait a minute, counsel. Counsel, stop. What's the record support for that?
That it was made preliminary to a proposed proceeding. She went through the letters themselves, which described the proposed proceeding, the grievances, the damages.
Well, I've read through the letters. I've read through the letters, and I don't see a proposed proceeding. Where is it?
It's the proceeding to seek damages unless there's a cease and desist and entering settlement negotiations within 2 weeks to avoid litigation, which is the purpose of a demand letter.
What if we conclude
Well, that's a conclusion that you could.
Sir, what if we conclude that those letters were not privileged with respect to tortious interference?
Then you would have to,
they allege with respect to defamation, they're not privileged also because there wasn't a good faith effort to sue. But let's go to the second one, which is much clearer. There's the thrust of the main claim is that there was an interference with her publishing contracts. And the district court concluded at the end, after all the analysis, accordingly, the court found that Halper's counsel demand letters were clearly subject to the absolute privilege, that plaintiff was on explicit notice that the privilege was being invoked, and that the plaintiff was warned about the consequences of filing a lawsuit based on these privileged letters. By filing this lawsuit and failing to withdraw it under Rule 11, the safe harbor period, plaintiff and counsel violated both Rule 11 and the court's admonition to Locafa 1. And it says, for these reasons, it issues sanctions. Now, several of those propositions are being challenged. And one of them is the letters were not privileged, and there seems to be some pretty good argument there. And the second was that
Your Honor, I'm sorry, didn't mean to.
Yeah, go ahead. I mean, the whole basis of the court's ruling has to be, in order to find this to be harassing or to be violate the earlier sanctions, this litigation has to be frivolous, as the court, that's what the court said.
We respectfully disagree. We think that you don't have to have a frivolous suit in order to have a
No, I'm asking you, telling you what the court found. The district court relied on the privilege of the letters and concluded because the privilege was there and plaintiffs knew about it. I mean, Locafa knew about the letters being privileged. Therefore, it was harassing and frivolous. And therefore,
and Your Honor, the judge made three findings, all laid out in the Mansfield case. One, the statement was made preliminary to proposed proceeding. Two, the statement was related to a proceeding contemplated in good faith. She ruled that she found as a factual matter that
based on what record? Again, based on what record?
Well, the record was what was presented to her by both parties. Mr. Biss had a full and fair opportunity to present any piece of the record on any of these topics that he wished.
Well, it's under the decision in Mansfield, that's going to be your burden to show that there was a proceeding contemplated in good faith and under serious, yes it is, and under serious consideration. And what I'm looking for is the evidence in the record that shows that.
Your Honor, under Rule 11, the trial court sits as the trier of fact.
We're back on the application of absolute privilege. And that's where these restatement issues come up. You may get to the sanction issue after that, depending on what you find, but in order to determine absolute privilege, that has to be shown. And if you haven't shown the absolute privilege, then you don't get any farther than that.
Well, all I can tell you is that the three Mansfield factors were identified and applied by the court, and she made factual findings. And those factual findings are not clearly erroneous. There's nothing in this record to say that the statement was not preliminary to a proposed proceeding, that it was not undertaken in good faith, and that it was disclosed to persons that had no interest in the matter. There is no evidence to support that.
For the lawsuit? In other words, the lawsuit alleged that it was a good faith. The letters were not in good faith, and the lawsuit alleged that those letters were not intended. And the letters, this is what the lawsuit alleged. Now, isn't that a matter of proof?
It may ultimately be a matter of proof, but for purposes of a Rule 11 proceeding, it is not. It is what is germane and relevant and evidence adduced in the Rule 11 proceeding. And right at this particular proceeding wasn't, even though it occurred at the beginning of the case, it wasn't an isolation. It was an extension of the earlier lawsuit. And that's what the court found.
In this case, we have just the two letters, right? And we have the complaint. That's the whole record, right?
Well, that is the only record that has been
Whole
adduced.
record in this lawsuit that the court could have considered.
Well, no, that's not true. The court can consider the 2 years she spent on Lakova 1, and the court
I understand
did consider.
that. I understand that. I'm talking about whether this litigation violated her earlier order. We know the history.
She said it did.
I understand she said it did, but the only thing we have in the record to support that is the complaint and the 2 letters.
And her prior admonition, as upheld by this court, when this court said we approve of her wait and see approach, she saw enough. And as a district court judge, she's entitled.
All right, let's stick with that. She saw enough. What did she see?
She saw that the plaintiff was returning to repeat the same defamatory allegations against the professor in a new suit when she had been told she had to be careful because she was close to being sanctioned the first time, but without prejudice was given leave to make sure she didn't repeat the same conduct. Now that conduct is simply outrageous. She called Mr. Halper a rat fucker.
Well, that wasn't in this suit. But I want to ask you the same question I put to Mr. Biss, and that deals with the Rule 11C5 limitation on monetary sanctions against a represented party. I'm not seeing where the district court dealt with that prohibition.
Well, Your Honor,
at all.
First off, I would, if this is directed at me, I would respond with the point that you initially raised, which is this was not raised either in the district court or in this court, and therefore should be considered waived. But more importantly, I don't think.
Well, there are 2 circuits that have considered this circumstance, and they have where the issue is not raised. Both the 9th and the 2nd Circuit have considered this, and they posited it to be an inherent conflict between the attorney and the client, where in effect the sanctions have been imposed, and now the attorney has a joint tortfeasor with him for the payment of the sanctions, and that permitted them to consider the issue. So if we did consider it,
well, first off,
I don't see where the record shows that the district court complied with the rule as to Ms. Lakova.
I disagree with that, but I also would remind the court that if there is a conflict of interest on the other side of the V, that may be a reason why issues are or are not raised, but it's not our responsibility on this side of the V. As to the issue of whether there was a basis to go after Lakova, the district court made express findings under B1 and B2. So, in your invocation of C is misplaced if, in fact, there is a finding that.
Well, how could it be misplaced? How could it be misplaced if you cannot impose the sanction for a violation of B2? And you just said it was a violation of B2.
It's a violation of B1 and B2 separately, independently. That's what I've been saying. And so the B1 is a legal basis under Rule 11 for imposing sanctions against the party because it was their intent to harass the plaintiff, harass the defendant.
Mr. Reed, before you end your argument, I want to ask you a question about the third element of the litigation privilege and the issue of disclosure to interested persons. The district court found that element wasn't in dispute because the letters were sent only to interested parties, that is the publishers of the allegedly defamatory marketing material. But Lakova in her complaint alleged that these threats were escalated to CBS Corporation, which was Simon & Schuster's parent company. And the district court didn't at all engage with that. Isn't that, that seems to me problematic on its face.
Well, I think that there is no distinction between the publisher and the parent organization.
How do we know that? How do we know that? Well, we know nothing about the structure of these corporations and whether or not the CBS has any day-to-day authority over the operations. We don't know any of that. And we don't even know exactly what it means to be an interested person.
Well, the interested person aspect has a long history. It basically means you can't go around broadcasting it to third parties. You've got to focus your request to parties that are the publishers, the speakers of the, in this case, defamatory internet marketing material. Those were the only people that were contacted. So, and those are the subject of the two letters. If I could just jump to one issue, that's the tortious interference claim. First, I would like to say that the plaintiff and her counsel did not raise that issue in the district court. Instead, what they raised was a argument that they presented to the district court, and she squarely rejected incorrectly. And that is the argument that there's no such thing as a privilege prior to the filing of a lawsuit. They cited the Lindemann case for that. It doesn't hold that. The Mansfield case basically made clear that demand letters are protected. Second, the issue is whether the intervening opinion from the Virginia Supreme Court in Gavagos, I guess is how it's pronounced. First off, you don't need to address that one because they never raised this issue. Instead, they attacked whether a preliminary, a communication preliminary to a lawsuit, which is not what the case is here. Second, this court in the prior iteration of this case, in the Provo 1, ruled that if a tortious interference case is predicated on a defamation claim, which this clearly is, that the tortious interference claim is invalid. And in fact, that's one of the reasons why this court dismissed or upheld the dismissal, quite frankly, of the prior tortious interference claim in Lacova 1. So regardless of the scope of the Gavagos opinion, under these facts, under the law of this case, in essence, that by bringing a defamation claim that was barred by absolute privilege and bringing a tortious interference claim, which was inextricably tied to the defamation claim, the end of the defamation claim is the end of the tortious interference.
I don't understand the linkage because in reading the complaint, basically they say the letters were sent regardless of the content. They also allege the letters were defamatory, but set that aside. They also say the letters were sent to destroy the publishing contract and that it succeeded. That doesn't make it, you could throw out the whole defamation claim and they would still have a cause of action for tortious interference, wouldn't they?
Well, according to this court in Lacova 1, citing the Virginia law as established in the Klein case, that if a tortious interference claim is predicated on a defamation,
it's not predicated. There's no allegation that the tortious interference was based on defamation. The allegation is the tortious interference was based on letters that persuaded the publishers to end the contract, and that the intent was to do that.
But again, if the tort is the defamation, then under
why don't you stick with my hypothesis?
According to this court, that doesn't state a claim. And so now, of course, this whole issue wasn't presented to the district court, so you don't have the benefit of the district court responding to that. But assuming it can be raised at this stage, that would be a total appropriate response under this court's prior precedent. Your Honor, I think my time might have expired.
Yeah, it is. Well, we want to get a chance to air these things. Thank you. All right, Mr. Biss.
Biss is muted.
You have a couple minutes.
Judge, I'm going to waive the rest of my time. I've been listening to the argument here. I think the matter has been fully argued and briefed.
All right. Well, I want to thank both counsel. We would normally come down and greet you in the courtroom, and that's a tradition we're not abandoning, but because of conditions, we can't do it. But we thank you for your arguments, and we'll adjourn court for the day.
Thank you, Your Honor.